Item?
Item number 4.
Yes.
May come after vacation. Matter relates to compromise. The parties are not able to come.
Okay. Yes.
Item 6, my lord. Item 6, I pray for. Let this matter come after vacation in tomorrow to continue.
Yes.
Page 2, item 10 to 22.
I don't know, item 10, my lord. After vacation.
10.
10, my lord, 10.
Rest matters.
Page 3, item 23 to 36.
And item 32, man. Select taken over after vacation, man. Compromise matter.
Partition are there.
Item 36, my lord. I'll take number 1 after.
Rest matter?
My lord.
Page 4, item 37 to 50. Page 5, item 51 to 63. Page 6, item 64 to 70.
Item 66, man. Item 6.
Withdraw.
Item 69.
My lord, item 66, man. After vacation, man. There is no entry, man.
Rest matter?
66, man.
Notice, madam.
Rest matter?
Item 68.
Yes.
Actually, item 68 today, I received the fresh notice. I'm appealing for the opposite party.
68.
68 today. Actually,
Huh?
Service sufficient.
My lord, I'm there for item
Then
68.
call for the opposite party.
Pardon?
6 time to file to file.
Pardon, my lord, I'm there for item 68. We are the
Page 7, item 71 to 80.
Your lordship.
At 2 p.m. Because statement has been recorded, both parties.
Yes.
My lord, item number 75. Permitted to withdraw, my lord.
Yes. Leave the member.
I have already filed. 75.
Your lordship,
God
item
bless you.
74. I will call up 2 weeks after your lordship. That's why Learned Senior is. on
Is it
application.
a rest matter?
Yes, your lordship.
Defects are there.
Huh?
Defects are there.
We'll remove
That
the
calls
defect.
for the petitioner, seeks 1 time to cure the defects. Urgent. 74. Next.
Yes.
Page 8, item 81 to 91.
Item 81, my lord, may come after vacation. Yes, ma'am.
There are some defects also.
Public service.
Yes, yes. By the time defect will be.
Then calls for the petitioner seeks to cure the defects pointed out for the registry. Urgent. Yes.
my lord, item 83 pending.
Huh?
Yes, item 83.
Yes.
Insufficient postal stamp.
And then you have
Postal stamp.
to.
But you have to give the postal stamp. Then comes for the petitioner seeks last and final opportunity to cure the defect pointed out by the registry. Urgent. Yes.
Page 9, item 92 to 98. Page 10, item 99 to 107.
My lord, item 99. May I pray to before launch, my lord, because of the both parties are appear before your lordship. And the opposite party number 2 is an asthmatic patient, my lord, a lady.
They are coming
Yes, my lord.
when?
Today, before launch, your lordship may
Yes, 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 take.
Oh, yes.
I am at a 50 million, 101 million.
Page 11.
101 million. But I am at a.
My lord, last time they have taken 1 month time. So now they are again seeking time.
There is opposition, let it be. Yes.
I am at a.
I will file the documents.
But he is opposing. Let us.
My lord, 1 month you have taken time without intimating me. Now you are coming.
No argument. I'll take it at the soon time.
Okay.
Yes.
I am at
Page 11, item
100.
108 to 113.
113, my lord. Mr. Sumodasan, he died on 13 April, my lord. Kindly taken up after vacation, my lord. Interim order to continue, my lord. Population.
101,
101.
item
I am at
114 to 120.
Item 114. I pray for after vacation.
These are revision petitions. All revision. Let the revision be on record. Be on board. Let it be on board. When it will come, I will recommend it. Don't wait. Let it be. Don't wait. Revision.
My lord, item 115, my lord.
Huh?
Some of the petitioner died, my lord. You have to take instruction. So let it be come kind of.
Then comes for the petitioner submits that some of the
5 petitioners are there.
out of 5 petitioners,
1 or 2 has been died.
some of the petitioners have died, and we want to ascertain the same urgent to.
After vacation.
Yes.
I'm at a similar.
Continue.
My lords, may I be permitted to make a mention?
Yes.
This is a criminal revision of the year 2017. My lords, all the pleadings are complete. My lords, the only difficulty is that the petitioner is going to retire. This matter may be taken up. I have earlier also mentioned, my lords, when this matter was before another bench. But
This is the criminal appeal.
no, this is a criminal revision where State of Orissa Vigilance is the opposite party. Offences under the Prevention of Corruption Act.
Revision included.
May I pray for this Friday, my lords?
No, Friday.
Plus next week, my lords, any date, my lords. Your lordship may.
He will include in the list. You be ready.
Yes, my lords.
Anytime I can take.
Yes, my
Whenever
lords.
the board
Yes.
is ready, I'll call you.
Yes, my lords. I'm ready. Grateful, my lords. My lord,
Someone, item 22, someone taken adjournment, wrongly taken adjournment. That is my matter, my lord.
Pardon to mention, my lord.
Yes.
Criminal revision 8/2019. It's a trap case, my lord. I am a doctor. Allegation against my wife.
Give.
No, we have given memos.
All memos you please give.
We have given, my lord. What the idiot should have been.
Which one?
Two memos I have given, fresh admission, criminal mistake.
Press which year?
23 matters.
23 we are completing.
And it is also 23 matters.
23 students come tomorrow.
Day after tomorrow.
Anytime.
Day after
See,
tomorrow.
23 we are exhausting.
My lord.
22 is exhausted and 23 we are exhausting.
My lord. Obliged.
Yes.
Pardon to mention,
Day after tomorrow.
pardon to mention, my lord. Item number 17 on my lordship's board, your lordship. Item number 17. Matter has become infructuous.
Then counsel but petitioner submits that the matter has become infructuous. This is
My Belgium matter, my lord. Can be taken up tomorrow, my lord.
give.
I'm at a BC. I am
40? Oh, yes. Tomorrow may not be possible. If you ask after tomorrow, what is this matter is about?
I'm at a BC, my lord.
We will see. It is listed, you are not doing what to do. Anyway, we will see.
One Belgium matter.
I'm at a BC 101, my lord. I'm at a BC 101, my lord.
Discuss 4,603/23,
Yes.
not listed till 6 months. Kindly be listed.
I am at a BC 101, my lord.
Yes.
Mr. Mahapatra is not good. His health condition is serious. So let it come after vacation. Interim order we continue, my lord.
101.
1.
Who is appearing for the other side?
Other is vigilance department. Other is vigilance department.
It's ill.
At the request of entry model conduct. Yes.
Pardon to make a mention, my lord. My lord, item 68. My lord, I pray for an adjournment, my lord.
Already adjourned.
My lord, interim order to continue, my lord. And my lord, item 84 also, may this matter be taken up 2 weeks later.
Defect is there.
You cure the defects.
Yes, ma'am.
Matricia Patnaik, then counsel the prisoner. She is one in time to cure the defects. Yes, ma'am. Call the prisoner.
Item 5. Item 5.
Oh, 5, na?
Item 1.
Lordship. But the matter has been settled up between the parties, matrimonial dispute, husband and the wife has filed affidavit, being the opposite party number 2.
Where is he?
Fast date. My lord, I am for the opposite party number 2.
The matrimonial dispute.
Matrimonial dispute, your lordship. For passing of proceeding. Wife has married.
Right, when can you bring them? Tomorrow?
Tomorrow, lordship. He has married. She has married elsewhere. So
you issue notice to the opposite party.
opposite party number 2.
Written with opposite party number 2. Next week. You file the process. Yes.
One copy will serve on.
Answer.
Yes.
Item 2.
Next week is not possible.
No, notice you.
Notice.
Item 2.
Password.
Item 3.
May I please? So here, the petitioner is the GRS, working as GRS, the lowest rank employee of the Gram Panchayat. He is before your lordship with a prayer to quash the vigilance PS case number 45 of 2021 in respect of him, in respect of the petitioner. The fact of the case is like this, my lord. On the allegation that regarding various irregularities in the construction work, the district magistrate and collector made an inquiry. That is Annexure 4. And in that inquiry, he found the Sarpanch and the executive officer to have misappropriated the fund. And your lordship kindly see,
Who are you?
GRS, my lord, working as GRS.
You are GRS.
The all point is that, my lord, your lordship know the
GRS.
yes, the employees, the lowest employee, it all occurred due to the defect of the irregularity committed by the Gram Panchayat, the Sarpanch and the executive officer. They issued a check and deposited in my account without my knowledge. So on that basis, I was no way concerned with any misappropriation or any illegality, irregularity. The report was made on various schemes, including the scheme in question of the Gram Panchayat. Annexure 4, your lordship can see 24.
Yes.
It's the inquiry conducted by the collector Burger.
Yes.
Your lordship can see the relevant project is page 26.
Yes.
Construction latrine of Budapani Bostel. This is the work done under the Gram Panchayat in question. And the next below that, your lordship can see, as the above vouchers could not produce the verification and expenditure is irregular, such as such has been verified by ex PO Sri Balkrishna Baria and Sarpanch and Srimati Udya Udluha. So accordingly, the collectors directed initiation of proceeding, also recovery. Then your lordship can see page 27, last paragraph. In view of the above facts, such and such has found and has been misappropriated by the Sarpanch, Srimati Udya Udluha and ex PO Sri Baria, and rupees such and such pension cash in hand with ex PO. Baria may be recovered immediately and necessary action may be taken against them. Ex-PO Baria already been suspended and FIR has been lodged against the Baria by video Gaisiler such and such. In this background, what happened? My mother made a complaint to the Lokpal and the matter was inquired. And on receiving that complaint, Lokpal issued notice to all, but not to me. Because there is nothing against me. So he didn't issue notice against me.
It was against the Sarpanch and
yes, Sarpanch video. That is also that I have annexed. And accordingly, he directed for an inquiry. In that inquiry to the Vigilance Department. And in that inquiry, Vigilance Department, I don't know with what ulterior motive, with their, even if there is nothing against me, they mechanically submitted, registered the FIR against me, for which I have been released on bail by this Honorable Court and the matter is pending there.
Lok Adalat, your mother has gone.
My mother, your lordship knows, if I would have been involved, my mother would not have never complained before the Lokpal. So in that figure, mechanically they have filed the FIR as well as now the charge sheet.
Yes, see the initial allegation is against the Sarpanch and PEO. And thereafter the collector says that recover the money. And if any necessary actions are required, you take it, no problem. The mother of the petitioner gives a complaint to Lokpal and you are making him as accused. That's his case.
Your lordship kindly see the check, Annexure 7.
7. Okay. Yes.
That's what I submitted.
At page 33.
Somebody else will
କହିବାକୁ ଦିଅନ୍ତୁ ଆପଣ ଏମିତି କହିଲେ ତ ମୁଁ ତ କହୁଛି the page 33.
Yes.
12,000. Next 34. 1,89,000 in favor of the petitioner.
Ashish Kumar.
Ashish Kumar Devata. Lordship got it.
Yes.
Then your lordship kindly turn to page 21. His own explanation.
21.
The submission that it has been deposited in my account without my knowledge, that is not correct. Your lordship kindly see para, 4th para. In this connection, your lordship got it. Page 21.
21.
No?
21. This is his explanation.
In this connection, it is respectively submitted that.
Para 4.
Para.
Yes, to the video.
I being a GRS, is duty bound to look after the NRGS work. Therefore, check number etiki for amount of etiki should not have been deposited in my account. However, I withdrew the said amount phase wise as per the direction of the PEO and Sarpanch. They made me to understand that as per my appointment letter, it has been stipulated that my designation so and so, and accordingly point number so and so, it has been stipulated that GRS has to obey the direction of the BDO so and so. So he has withdrew the money for the purpose of the work. Then your lordship turned to, then a complaint was lodged before the Lokayukta by one Sailabala Devata on 13/3/2021, page 29, annexure 5. Alleging there are allegations against the ex-sarpanch and another PU for illegalities in construction 1 and misappropriation. Then in procedure 21 of the Lokayukta Act, Lokayukta issued notice to the concerned officers and also directed the vigilance to conduct an inquiry. Inquiry was conducted. An inquiry report was submitted before the preliminary inquiry was submitted before the Lokayukta. And during investigation, your lordship then come to annexure 8.
Yes. Yes.
Third para. In compliance to our order, Director of Vigilance has submitted the investigation report. It reveals that total misappropriated amount is so and so. On perusal of the investigation report, we find that apart from Srimati Udian Luha and Sri Bhaktaram Bariya, the Director of Vigilance has made one more official, namely Ashish Kumar Devata, the present petitioner, as accused for misappropriating rupees 93,000 someone out of the total misappropriation. According to the investigation report, Ashish Kumar Devata could not show the case records and vouchers towards execution of work. On physical verification also, it was found that he executed less work worth 81,000 so and so against the advance of 1,89,000 taken by him for construction of the toilet. Not only this, he could not submit the voucher for 12,000 towards upload of so and so.
There are materials.
No, this is not.
Then your lordship
I will submit this.
Then your lordship
This is all I submitted to you.
having regard to the fact and situation, the particularly with regard to the finding of misappropriation against Ashish Kumar Devata, we in exercise of power conferred under section 22 of the Odisha Lokayukta so and so call for information from him in the matter. So the fact that he has not been intimated, no explanation was sought for in statutory provision, he was called for. And after considering his explanation also, the Lokayukta satisfied and giving opportunity of hearing to the petitioner, the Lokayukta is satisfied that there is prima facie case against him, and they directed the Vigilance Department to submit the charge sheet. Then charge sheet was submitted on 30/9/2022. Cognizance was taken on 14/10/2022. And since then, the petitioners are not appearing and case is lingering.
Yes.
We are in 2024.
Yes, sir.
This totally, this is all I submit. This because it all goes in my support. I have submitted here. As I submitted beginning, the petitioner is the lowest employee. He has got no. He cannot say.
The fact that 2 checks were issued.
No. My lord, your lordship.
These checks,
my lord,
it is deposited in your
my lord,
account.
somebody
You have withdrawn it.
I have that is what I have stated on my affidavit. It's not.
Those are matter of trial. I can't.
As your lordship see, but the whole point is that
I'll give you opportunity to argue those things at the.
no. But your lordship may kindly call for the record because it will an empty.
I'm not.
This is an empty formality for the trial is concerned. If the
Maybe because
let me place
this.
it.
Is inquired.
My lord,
Lokayukta is inquired. Opportunity is given.
My lord, your lordship can see. Your lordship can see. I just said because this question of admission. My learned friend has not taken any instruction. He is relying on my document. He is submitted. And if the documents would have been gone in against me, definitely I would not have filed it. The fact of the case is like this. In detail, little bit I am submitting. The explanation I have given to the video, not to the Lokpal. Your lordship can see. The page 20 annexure 2. It's a distorted submission is creating a confusion, man.
Yes.
The annexure 2, the block development officer. So-called implementation such and such to the. Your lordship kindly see, this is so-called issued by the annexure 1 by the video. I have replied in annexure 2.
Yes.
With reference to the subject concerned above, I do here.
That's what he read it at para 3.
para 3. That regards to second allegation of such and such by check number such and such has been credited into my account for a project named construction of latrine and bus stop, Gudepali, during my tenure as GRS. As GRS is no authority to keep any records, and I will be asked to keep a record. Suppose a peon is not.
It was once it is deposited in your account, you know that you have withdrawn it.
No, your lordship can visualize.
And you kept quiet.
Yes.
Unless
No. The GRS, your lordship can see a peon. The deputy registrar will deposit the amount in his name, and he will say that the amount is deposited, which I have stated. Your lordship can, your lordship is. So I know the whole point is that here the hierarchy, he has deposited. I have not deposited. So thereafter that it has been deposited and you will do as per our instruction. Then their higher official will say that you withdraw and pay him. Should I not do that? And is it expected the higher officials are not able to do? A GRS, the lowest employee, will say that this deposit has been done without my consent, this thing, that thing, and he will go to the reported vigilance department.
Everything is a matter of
No,
the state.
Anyway, as your lordship,
I will give opportunity.
If your lordship, I am sure that if your lordship will go through the record, then your lordship can receive for a moment. This is the reply.
Okay, then I'll reserve it.
This is the reply, my lord. Your lordship can receive.
I'll read everything.
Just
yes.
Paragraph 3. As per the instruction and direction of Gudepali PO and the Sarpanch, I was looking after the said work. The peon is looking after the said work. They were looking after the works and preparing the bills and vouchers. They were doing. As it was stipulated that they had to carry out the work, not the GRS. As per prescribed norms, the check number such and such was issued in my account. Out of the said account, they made the payment to the concerned persons who are engaged in the construction work from time to time, and because they are the drawing and disbursing authorities. In view of the facts, I said, I have never misappropriated any government money or any account, more particularly from the CPF and such and such. Next paragraph. In this connection, it is respectfully submitted that I, being the GRS, is duty bound to look after the Monrega works. Works only. I am not custodian of any paper, document, or check, anything. Therefore, check number such and such for an amount of ₹1,89,000 should not have been deposited in my account. However, I withdrew the said amount. Yes, the lowest employee as the innocent man, because they speak the truth. The higher officers, because mine becomes complicated. However, I withdrew the said amount phase-wise as per the direction of the PO and the Sarpanch, because they have made me to understand that as per my appointment letter, it has been stipulated that my designation is multi-purpose assistant GRS, and that according to point number such and such, page such and such, job chart number such and such, it has been stipulated that GRS has to obey the direction of the BDO, program officer, Sarpanch, Panchayat officer. He has been taught. He has been given a PhD thesis.
Your mother is involved in this?
Involved, she was public. She is a public serving woman. She was earlier in the Sarpanch, and if remotely also I would have been connected, she would not have.
It is because of the sharing of booty between.
No, not.
Anyway, I'll pass the order.
My lord, your lordship kindly see.
I'll pass the order, sir.
Well, let me place a little bit.
He
has completely. No, he has with distorted things. Yes, my land friend has submitted. I'm just clarifying. It is
right. I'm not referring to his. I'm referring to your petition.
I understand, but the ballot, your lordship knows that little bit of assistance is helpful to the court. That is why your lordship gives us time.
Relevant part I read it.
Another 2 minutes.
Yes.
I will not take much time. I'm not that so much anxiety with any of the either way.
Yes.
However, I withdrew the said amount phase by such and such Sarpanch, because they are made me to understand that as per my appointment letter, it has been stipulated that my designation such and such, according to point number such and such, 3 job card for GRS, it has been stipulated that GRS has to obey the direction of the BDO, such and such, Sarpanch, Panchayat officer, executive officer. Accordingly, I being a low paid employee, my service is placed under the disposal. I had no other option than to carry out the direction. I had never any intention to misappropriate any government money. I have misappropriated any amount. I have never withdrawn any money from the CPF or SFC accounts directly at any time. Then you'll also kindly see. This is the collector to the all collector, director Panchayat, and collector has made a thorough inquiry. Your lordship kindly go through it.
I read it.
Yes. Thoroughly. So this is, they have not, if the collector would have found.
The money is routed through you.
Money not routed, with all respect, not routed.
Anyway,
money is deposited in the Gram Panchayat,
right.
And the authorized signatory is the Sarpanch and the executive officer. Yes. They issued the check in my name, yes, for which can I be held responsible? That is the only thing. They issued the check in my name, that is, and they deposited and said that you withdraw it as and when as per our direction.
Right.
So accordingly, they directed me. I withdrew. I paid the money for the construction. That is the only thing this he has done. There would have been in material. Collector would have also directed his action against me. So that is not there. And the your lordship kindly see, my friend said the Lokayukta issued notice to me. That your lordship kindly see, the Lokayukta has not issued notice to me. I have stated on my petition. And this whole point is that because Lokayukta directed to make an inquiry, mechanically they made an inquiry and by overlapping that since there is material, he issued the thing. Probably he thought that against whom he has issued notice, there is material. But accordingly, though I was nothing to them, he has not perused my explanation. He has not perused the collector's inquiry report, nothing. The Vigilance Department not inquired either find out the truthfulness, whether the money was paid or not, and accordingly it has been done. This is the only thing.
Thank you. Yes.
Otherwise, the whole point is that the low paid employee only suffers in our country. The higher paid, se gote sabale kohutile. Bada bada macha ko ana choto choto chingudi au se ani ke kono. We know, as your lordship knowing me better than me, because I don't have the exposure what your lordship had.
Yes. Thank you, sir.
Item 5.
Yes. 5. 5, huh?
Item 5.
4 is there, yes?
4 is there.
Yes.
I'm sorry.
Yes.
এটা তিনটা অর্ডার রিজার্ভ রইল অর্ডার রিজার্ভ
In this case, on the other day, I submitted that the entire case record be called for.
One more time. Yes, I not come, my lord.
A complaint
Come up from
petition was
Custodial.
filed that was transmitted to the police. And
He is speaking one more time.
My lord.
I have no objection.
Mr.
I have a request. If I will remain free, I will argue. Otherwise, a submission will be made on my behalf.
No problem, sir.
No.
Your all juniors are competent.
Yes, I'm going to contest election.
And I don't know whether your juniors will follow you or not. Yes.
Item 7.
Yes.
Item 7.
What is this matter? Wasi,
My lord. Earlier, my lord also, that has been urgent.
That it matter. The matter was taken up on 10/1/2024. And it was adjourned to 4/3/2024. Whether in the last occasions anybody appeared?
Urgent or
Adjourned. When the this matter is called up today, none appears. In the interest of justice, one more opportunity is given to the petitioner. Please the matter on such say, it made clear that no further adjournment shall be. Yes.
Item 8.
This side of the vacation, huh?
Yeah.
This side. Yes. 8. Yes.
Item 8.
This matter is also listed 11/1/2024. Thereafter, it was listed on 4/3/24. When the matter was called up, none appeared today. In the interest of justice adjourned. It's made clear that this is for the disposal for the next data hearing.
Item 9.
No further adjournment. This side of the vacation. Yes.
Belgium method.
Yes.
In this application, petitioner challenged the order dated 5/9.
When you got the
9. Bail 3996 of 23. Bail 3996 of 2023. দুইটা কেস আসছে। ফার্স্ট কেসটারে বেল অন 6/11/2006।
First case, right?
NBW 5/11/2022।
500, huh? Next.
নেক্সটটা হচ্ছে বেল হচ্ছে 27/7/2010। NBW 5/12/22। সেম কেস।
আচ্ছা 12 নম্বর আইটেম না
ନାଇଁ ନାଇଁ 9 ନମ୍ବର 9 ନମ୍ବର ଦିଟା ଆଇଟମ ଅଛି ମିଶି
ତମର ତ ଗୋଟେ ଅଛି।
ଗୋଟେ ନାଇଁ ନାଇଁ ତା ଦେହରେ ଆସିବ ନା ଆସିନି ତା ଦେହରେ ଦିଟା ହଁ
ଦିଟା ଅଛି ନା।
ହଁ 2684 ଅଫ
2684 ବି ଅଛି ନା।
ହଁ
ଦିଟା କରିଦେ 2684 ରେ
ବେଲ୍ ହଉଛି 27/7/2010
ହଁ
ତାପରେ NBW 5/11/2022 ସେମ୍ କେସ୍
Second case also 500.
ହଁ ସାରି ଦିଅ
ସେକେଣ୍ଡ
ସରି
କେସ୍ ଅର୍ଡର ହେଇଯାଇଛି ବୋଧେ
ଅର୍ଡର ହେଇଛି ଅର୍ଡର ହେଇନି ବୋଧେ ନାଇଁ ନାଇଁ ହେଇନଥିବ
ନାଇଁ।
ନାଇଁ हैं? ହେଇଛି
It is cost. Hereby discussed. 3/2023 ରେ cost ହେଇଯାଇଛି।
ଆଚ୍ଛା ଆମକୁ ଏବେ ଦେଇଛନ୍ତି
First time, huh? First time. Second, yes.
Item 10.
Adjourn, huh?
Item 11.
private party
देखो कौन है क्या सेम राजेंद्र नारायण राव मैंने भी लिख दिया डेटा 7/2/2024 थोड़ा चला तापरे 13/3/2024 when the matter is called up none appears today the subject is given to next week it made clear that no further action.
Item 12.
May I please your lordship. My lord, I have filed this application challenging the order passed by the Lord court below. While that disposing this application, this court below was pleased to reject my application on the ground that my lord, I have annexed that my lord, order of the Lord SDJM Kendrapada, my lord, passed in criminal miscase number 16 of 2019, in which my lord that last my lord paragraph upon perusal of the case record, it is evident that the original money receipt of Canara Bank is attached to the case record. In the meantime, GR case number 882 of 2018 has already been disposed of by this court, and the accused is acquitted in this case. I have, my lord, annexed the acquittal order, judgment copy of the order, my lord. But upon perusal of the charge sheet submitted by the IO, in this case, it came to the notice of the court that the IO had submitted the preliminary charge sheet against one accused, keeping the investigation open under section 173 surplus 8 of the CRPC. Hence, there is part file of this case which is open, and the case is not yet over, even though one of the accused has been acquitted. The petitioner has the possession of the furniture shop and is running the same smoothly. But releasing the bank guarantee submitted by her at this stage would not serve the purpose, as the investigation is still not completed, and new facts may came out later, changing the fact of the case. At this juncture, the petition filed by the petitioner.
You got acquitted.
Yes, my lord, that I have not the accused, my lord. That another person who is my relative, as per the prosecution case, he was the accused in a particular case, and that the investigating officers presume that he has collected some illegal money and he has distributed that illegal money in their relatives, my lord, within their relatives. And my lord, I have a shop, furniture shop, which was seized, my lord, in this case, in which, my lord, the petitioner, my lord, accused persons has already been acquitted. And then while that releasing my shop, that was a condition that I will furnish a cash security of rupees so and so. 5 lakhs, 5 lakhs, 70.
Want
that money released in my favor.
My lord, the order of 2022, my lord, by the time investigation kept open, my lord, I'll take instruction whether investigation completed, my lord.
ତାଙ୍କର ଫର୍ମାଟ ସେ ସବୁ କେସରେ ଆଜ୍ଞା ଇନଭେଷ୍ଟ ହଁ ମୁଁ ମାନେ
170. See, what the court says that 173(8) is open.
ଆଜ୍ଞା
So therefore, he is not allowing.
ଆଜ୍ଞା
But 2020 order, what he says that it might have been over now.
ହଁ
We can
ତା ଦେହରେ
discuss.
ଆଜ୍ଞା ତା ଦେହରେ ବି ଆମର ଆକ୍ୟୁଟାଲ ହେଇସାରିଲାଣି ସେ କେସରେ
Issue notice to opposite party.
Rather, you also
opposite
another
party.
opportunity if you also direct the court below, my lord, charge sheet submitted in the meantime, he'll file fresh application.
ନାଇଁ ଚାର୍ଜ ସିଟ୍ my lord file and then
ହେଇଯାଇଥିବ ଏଠି better seat ଆଉଥରେ
ଆପଣ ବୁଝୁନାହାନ୍ତି, that's
objection
a
ନେଇଯିବ
good idea.
ଆଜ୍ଞା
ଏଇ ଯୋଉ objection ନେଇଯିବେ କାଇଁ ଆମେ ପୁଣି ମାଗିବା
Right.
charge sheet, my lord.
1 minute. Petitioner is agreed by the order dated 4/11/2022. whereby his application for release of the bank guarantee submitted by him, bank guarantee or cash security?
My lord, cash security.
Cash security furnished by him for amount of 5 lakh
5,76,766 rupees.
Has been turned down. Has been turned down on the ground that the investigation under further investigation under section 173(8) CRPC vis-a-vis the other accused persons are still open. Learned counsel petitioner submits that the accused person, the court below, the court of subdivisional SDJM district Kendrapada, the court of SDJM district Kendrapada, while order dated 14/3/2022 in GR case number 882 of 2018. Have already acquitted the co-accused person.
The principal accused person.
The principal principal accused.
How can I answer case?
Therefore, there is no point retaining the cash security furnished by him. And he further submits that he is not even an accused in the present case. But in the course of investigation, the shop in question was how the security was taken?
That I have a shop. So that investigating officer presume that the main accused handed over some amount to this person and he has opened the shop.
The petitioner was made to furnish the security of 5 lakhs rupees, furnish the cash security as mentioned above, on the allegation that the principal accused might have invested the amount in the furniture shop the petitioner is running. Petitioner Mr. Ragada IPS for the state and submits that the impugn order was passed on 4/11/2022. By now, the final charge sheet might have been filed by the police.
But my instruction might not filed.
Might have been filed by the police. Taking into consideration the aforementioned fact, I am of the considered view that the petitioners may move a press application before the court below. And if such application is moved, the same shall be considered by the court below on its merit within 15 days from the date of moving the application. The impugn order dated 4/11/2022 passed by the SDJM Kendrapada in criminal match case number 16 of 2019 is cause. With the petition is allowed with a provincial liberty. Yes.
There is another item.
And then, my lord, that the court below.
No, my lord. Here is that I am the financial institution. The petitioner is the financial
Same
institution.
case.
Same case.
Yes.
Petitioner is the financial institution who has financed.
You move by that time, everything might have been over.
Hello?
You move an application.
I will move the application, my lord, and it will dispose of within 15 days, my lord.
That I have said.
I am the financial institution who has financed opposite part number 3 about 1.70 crores rupees.
State Bank of India.
State Bank of India. I am State Bank of India. When the account is in force and the documents are in force and account is going in and in order, that I have received a letter in annexure 2, page 21, 10/7/18 to freeze both the account.
Okay.
So by virtue of that, my finance is there. I am dealing with public money. I am not in a position to run. He is not allowed, and I am not in a position to run the account. And moreover, in that account, there is a fixed deposit of 34 lakhs is there, which also I am not able to utilize in the loan account.
Whose account is this? These two? Whose accounts are that?
That is the
principal accused.
Opposite party number 3. That is Benjiri Bibi. He is also suspected that finance has been made.
সেই সময় 18-19 মସିହାରେ ଯୋଉ କେସ୍ କଲେ ସେ କେସ୍ ରେ ସବୁ ଯାକ କଣ କରୁଛନ୍ତି ନା ଆମର ଆକାଉଣ୍ଟ ଗୁରିକା ଯାହା ଆମ ରିଲେଟିଭ ମାନଙ୍କର ଅଛି ମେନ୍ ଆକ୍ୟୁଜଙ୍କର ଯେ ରିଲେଟିଭ ମାନଙ୍କ ନାଁରେ ଅଛି ସବୁକୁ ଆଜ୍ଞା ଫ୍ରିଜ କରିଦେଲେ ଆଉ ଆମର ସବୁ କ୍ୟାସ୍ ସିକ୍ୟୁରିଟି ହେରିକା ସବୁ ବି ମାନେ ଇଏ କରିଦେବେ ଆଉ ତାପରେ ଇନଭେଷ୍ଟିଗେସନ ଜମା ଟୋଟାଲ ପ୍ରୋଗ୍ରେସ ହିଁ ନାହିଁ ଆଉ ଯାହା ଯିଏ ଆକ୍ୟୁଜ ଆରେଷ୍ଟ ହେଇକି କଷ୍ଟଡିରେ ଥିଲେ ଯିଏ କି ମେନ୍ ଆକ୍ୟୁଜ ପ୍ରିନ୍ସିପାଲ ଆକ୍ୟୁଜ ଆଣ୍ଡ ଦେ ଫାଇଲ ଦ ଚାର୍ଜ ସିଟ୍ ଏଗନେଷ୍ଟ ହିମ୍ ବିକଜ ହି ୱାଜ ଇନ୍
How many
କଷ୍ଟଡି
accused are there?
there are several cases my lord 5 to 6 cases are there but accused is one and he has already released on bail by this honorable court.
Bail is something different.
And my lord, but they are keeping investigation in all the cases open and seized the bank account, etc. Entire transaction, my lord.
Different FIR.
Yeah. I see total
Same
neither
FIR.
6.
neither they are my lord.
Same FIR.
Nahi, same FIR no. Tankota case
Number 6 of the 18 it ହେଲା ଭୁବନେଶ୍ୱର PS case number 6 of the 18 ପରା
ହଁ
ଦିଟା ବା
ସେ earlier case ରେ
ଏଇଟା ହଉଛି
FIR
ଆମର
କଣ ଥିଲା?
technically they seized all
ଏକା ଦିଟା
our
ଗୋଟେ case,
economical
ଗୋଟେ case.
transaction my lord.
6 of 2018 ଗୋଟେ ଏକା
Era
case.
same FIR.
ସେ case ରେ ସିଏ acquittal ହେଇସାରିଲାଣି main accused he has already been
You
acquitted.
had moved application before court below, no?
No, we have
You
not.
moved the application.
Oh.
You Land Council order petitioner seeks to withdraw the present petition to move an application before trial court ventilating the same grievance. If such application is
Upon
moved,
banking
the
koriyo,
same
court
shall
production.
be considered within 15 days. You also move the application. You get an order thereafter you come.
Aye.
Dispose of both the times. Yes.
Item 13,
Within 15 days ଭିତରେ ସାରିବ।
And that 15 days.
15 days.
May I please your lordship? The petitioners are the in-laws, my lord. Challenging the order dated 2/6/2022, my lord, the order of cognizance passed by the Lord SDJM, Panpos, for offence under section 498A, 406, 506.
Yes. What are the allegations?
Allegation, my lord, in a sweeping manner, they only demand of dowry, etc. But
Common
no case. Yes, no case against her husband. And now 20 years have been passed. She was staying with the petitioners now in the same room. But she is filed this case in the year 2004. And the सी किंतु compromise କରିବାକୁ ରାଜି ହଉନି only cooperate କରୁନି ସେ ଗୋଟେ ତାଙ୍କର ଯୋଉ share ରେ separate house ହେଇଯାଇଛି ବର୍ତ୍ତମାନ ସେ ସେଇଠି ରହୁଛନ୍ତି କିନ୍ତୁ case file କରିଥିଲେ as her one of the relative was in police he
2004 issue notice to opposite party number 2 written within a week before vacation 20th file the requisites.
Stay of the further proceeding.
File the requisite on 20th. I'll quash it. 2004 FIR. They are staying together. Why the in-laws will suffer? I'll quash it. Bring it.
My lord, further proceeding to be stayed. କାହିଁକି ନା ସେଟା ପାନପୋଷ ରେ ଚାଲିଛି ମାନେ ଅନୁଗୁଳ ରେ ରହୁଛନ୍ତି ବହୁତ difficult ହଉଛି ଯାଇକି day to day litigation.
FIR?
My lord.
FIR କେବେ ଫାଇଲ ହେଲା?
2004 ରେ ଆଜ୍ଞା ଗୋଟେ
2024 ଏବେ ଯାଏ କିଛି ହେଲାନି ଦି ଦିନରେ
ଆସୁଛି
2004 ରୁ 2024 ରେ କିଛି ହେଇପାରେ
ଚାର୍ଜ ସିଟ୍ ଟା ଆଜ୍ଞା
ଆରେଷ୍ଟ ହେଲାନି କିଛି ହେଲାନି ବର୍ତ୍ତମାନ ଆପଣ ସବୁ all apprehension right now within 2 days as the police is standing in front of your door.
Charge sheet is filed my lord in the year 2022 30/1/2022
ତାପରେ କଣ ହେଲା
ତାପରେ subsequently charge sheet filed
ଆରେଷ୍ଟ ହେଲେ ଆପଣ 2022
ଆଜ୍ଞା
ଆରେଷ୍ଟ ହେଇନାହାନ୍ତି କିଛି
ନାହିଁ
ତାହେଲେ ଦି ଦିନରେ କଣ ହେଇଯିବ 20th ko you bring file the process fee bring here I'll quash it I'm telling you because she is staying with her husband in the same house and why the in-laws will suffer file the process fee bring here quash it yes
item 15
yes
14 report
मतलब
yes sir
बंदो ढाकी
14 14 चलছে না
मतलब prefer day after tomorrow my lord.
See on 30th January 31st January you have taken date and again on March you have taken date.
My lord, I will give some
now you yourself is fixing a date.
decision, some judgments I will.
When court fix the date you don't come. Now you fix a date.
Barred by limitation. That is my ground, man.
But you said that there must be something.
Let us see.
Item 16.
No, no, let us see. It can be disposed of.
खाली
But
decision देवे बोली day after tomorrow.
what is this matter? Let us understand.
I have challenged the order, the power by limitation, my lord. The offense alleged, my lord.
This is for quashing of the entire proceeding. Huh?
Yes, my lord.
What is the stage?
Of
Charge sheet has been filed.
most charge sheet already filed. On my issue, they
Offenses?
they have not taken any cognizance. That is my ground, my lord.
143.
506 is 3 years punishment, my lord.
Your grievances, they have not, trial court has not taken cognizance.
Yes.
I'll ask you to take cognizance.
खाली तो नवाब
Charge sheet is filed. Your grievances, cognizance is not taken. I'll ask the court to take cognizance or what to do.
ऐसे बार बार limitation 5 years in the past, my lord.
Bar by limitation, 506 is there, what, 149?
Here,
You're talking about 468, TRPG.
yes, my lord.
How it is barred?
Next date का होती है खाली ऐसे decision ले खाली day after tomorrow.
Next figure.
May I submit something?
It is made clear that no further adjournment shall be given in this matter. You know, Mr. Patel, you don't have a case. So therefore, that is the problem. Yes.
Item 16.
May I please, your lordship?
Yes,
My lord, here in this case, the present petitioner challenging the order of cognizance, my lord, which is in Annexure 1, page number 8, my lord. My lord, here in this case, initially the FIR registered against 2 persons, and after that, the 161 statement also, there is 2 injured persons. They are not stated anything implicating the present petitioner, my lord. But the police, while submitting the charge sheet, made the present petitioner one of the accused in this case, and the cognizance was taken, which is under challenge, my lord.
307.
My lord. 341, 294.
What is attributed to you?
My lord.
What is attributed to you?
My lord, there is other witness who is were examined up in the month of February. They are stated that there is 4 persons are assaulted this person. So, my lord, considering
You are
that,
one among them.
my lord. But the injured persons, the complainant, they are not stated anything. And the FIR also registered against 2 persons. I am not in that FIR also.
I know, I've seen it, but there is nothing in it.
Notice
You raised all this point before. When at the stage of framing of charge, there are 161 statement according to you by the other witnesses. Those who said that 4 people have attacked. You are only that the victim who was assaulted, he in his statement under 161 has not said anything. That's the only case. So therefore, you have to argue this thing before the court below. Move application. I'm giving that liberty. And counsel for the petitioner seeks to withdraw this petition to raise all the points for the court below by moving appropriate applications. Seeking discharge. With the efforts with the said liberty disposal.
The person is also not in bail. The person is showing at the charge sheet that he is an absconder person. And the NBW issue.
I know, that is the reason you are here.
My lord, the order
I have given the liberty. Then counsel for the petitioner, I am recording your. Then counsel for the petitioner, then counsel for the petitioner submits that in the petitioner name was not mentioned in the FIR. However, charge sheet has been filed against him on the basis of the statement for the witnesses and recorded under 1 CRPG to the effect that 4 persons have caused injury to the victim. The present petitioner is alleged to be one of the statement of, however, when the victim statement was taken under the 161 CRPC, he has not uttered a single outage being committed by the present petitioner. Therefore, the version of the witnesses are seriously doubtful, seriously doubtful. I am not inclined to interfere in this matter at this stage. However, petitioner is granted liberty to move the appropriate application to court below, raising all these points at the appropriate stage. Thank you. Yes, next.
Item 18.
17
My lord, challenge the order of cognizance dated 25/11/2016, my lord.
Yes.
Offense under section
2016
41 to 94.
Today we are in 2024. Much water might have been flown under the bridge now.
Kindly consider surrender religion well, my lord. Kindly consider.
You are absconding.
My lord. Same village, my lord.
What are the offenses?
Lord,
Seizure 16 case, man.
What are the allegations against you?
while the daughter of the informant coming from her college, on the way, the petitioner detained to her and abusing in filthy language and assaulted by means of knifing. And the petitioner and the daughter of the victim were loved each other since back, my lord.
Where from I get it?
My lord?
Where from I'll get this story?
My lord, I have filed the charge sheet, my lord.
Injury is simple.
My lord.
Injury is simple, you will get the bail. Why are you not going on applying for bail? Simply
16 case.
Huh?
2016.
Good side, good gaaro, good side.
I'll give that liberty that 16-year delay can be covered. Now you go. I'll record it that it's a simple injury case. That's better.
Surrender.
NBW has been issued. What happened? The trial court is not proceeding after charge.
No, my lord.
That's why absence that court can.
NBW to issue proceed issue. I might have thought for issuance of NBW POPO issue. Get the instruction. I'll keep it next week. Mr. Goda? Take instruction. 2016 something might have happened. If NBW is issued, then what we'll do is we'll quash the NBW and allow him to appear and seek remedy. Keep it next week. Keep it next week. Issue notice, Mr. Ragada accept notice. Next week. Yes.
Item 19.
May I please? The lordship turn to
yes.
Page 12, my lord. Edited. Certified copy I have annexed, my lord. Also, I have given the Xerox copy of the certified copy.
Yes.
164 statement. The lordship kindly peruse.
This is 164.
Yes, ma'am. No case is made out, my lord. So far as 376 AB is concerned, my lord. Your lordship kindly peruse.
Read that.
ବରୁଣ ଦାଦା ମତେ ଡାକିଲେ ମୁଁ ଗଲି ମୋ ଭାଇର ମୁଣ୍ଡ ଫାଟିଗଲା ଓ ମୁଁ ପଳେଇ ଆସିଲି ଆସିକି ମୁଁ ଲୁଚିଗଲି ମୁଁ ସେ ପୁଣି ମତେ ଡାକିଲା ଓ ନ ଯିବାରୁ ମତେ ଝିକିଲା ଓ ଛାତକୁ ନେଇଗଲା ସେ ନଆଇଲା ମତେ କରିଦେଲା ଭାଇ ଆସି ଡାକିବାରୁ ସେ କୁଆଡେ ପଳେଇଲେ ଭାଇ ମତେ ଘରକୁ ନେଇ ଆସିଲା that is the statement. How 376
has been settled between the parties. I have filed the affidavit along my power.
Parties are there.
Yes.
Mr. Goda, let's take it up. What are the offense? What are the allegations? What are the allegations?
No. Lord, 3 SCST acted. 3 SCST.
323 is blah.
What 354 or 360? 360.
Madam, obliged. At the instance of opposite party number 2, who is the author of the fire?
Informant.
Who is Ramesh?
He is also an
Opposite party number 2, Ramesh.
Asinan.
Who is opposite party number 2?
No, Sasi Malik question.
Who are the accused?
Accused is also present. Babu. No?
There are two accused, Babu and Padmini Vishwal. Where are they?
Babu is present also.
Padmini?
Padmini's wife is not coming.
And who is Ramesh?
Ramesh Millard, one of the informant. Millard.
No.
No. Informant Ramesh.
If be sure about it, I'll take it up at 2 o'clock.
2 o'clock.
Be sure about it and call everybody.
Everybody, Millard.
Everybody accused has to be there. They are not VIPs. They have committed a crime. They have
Yeah,
to be
Lord,
there.
well,
Why lenient?
Then it will be tomorrow, Millard, because some difficulty.
Okay, tomorrow.
Tomorrow.
Don't show any leniency to the accused. Not that they throw some money to the lawyer and will give.
Let's
bring them.
Yes,
to court.
Tomorrow, Lords.
Tomorrow, no problem.
21.
And who is Ramesh? Just check it up. Why have you implemented as the opposite party number 2? If he is an accused.
Inform.
And who is he then?
See the informant.
Ramesh, who is Ramesh? There are two opposite party, 2 and 3. Who are they? One is informant, one may be the victim.
Yes, sir.
Check it up, huh?
Yes,
Check it up. Yes. Yes.
21.
21, my lord. Today I see single personal appearance, my lord. Take instruction for IIC.
Sorry?
A personal appearance में थिला IIC single.
I didn't follow you.
Nothing Roj.
That case, well, deep and dumb gal,
Deep and dumb.
compromise your receipt not inclined. That is me, ask the IO. I contacted the IO. IO stated that, well, the allegations are so serious, but she is not able to take whether matter compromise. And
The father came and appeared.
Father and the parent.
What to do?
Ask him how say. He कही पर तब एक कौन है चुरी कही पर नहीं देखो and what is the matter term compromise that is not 276.
I have asked you to file affidavit. Where is the affidavit? She's a deaf and dumb girl.
My lord.
She has been subjected to sexual harassment, rape and all. And you are saying settlement has taken place.
My lord.
How will you confirm that the girl is, adequately compensated?
My lord, in this regard, I may be permitted to say something, my lord. Deep and dump is some persons, ताको जो
Court and acquitting.
नहीं ताको भी उड़ा appointment हुआ पे.
Your lordship may be expedited the trial, so that is all properly fulfilled, my lord. You will go there.
Yes.
Still,
ताको investigation भी open है. Investigation has not been, my lord.
यहाँ पे ऐसे से अच्छी दायित्व my lord, the case in 2022. In view of the compromise, my lord, the lordship directed, there will be interpreter will there, my lord. Trial could be acquitted. That will their proposal solved, my lord. Otherwise, my lord, this is not case for question, my lord.
So IO will appear 2 o'clock.
IO 2 p.m. IO से क्या कहले थे 2 o'clock.
Okay. 20 after 25.
2 p.m.
Yes. 22.
May I please, Your Lordship?
22.
My lord, I have filed this application for quashing the criminal proceeding, my lord. Mudulipura PS case number 22, dated 29 August 2022, my lord. My lord, allegation in the FIR, my lord. Both the petitioners are working as home guard, my lord. Home guard, and allegation against them that on the direction of their IIC and ASI Maji, they tried to they had gone to ATM or withdrawn the amount of rupees 10,000, which ATM belongs to accused persons who arrested in NDPS case at Malkangiri, my lord. That is the case, madam.
Investigation is going on.
Investigation completed.
You have filed only the FIR copy.
FIR copy. My lord, I have only submission, my lord. Kindly call for the CD, my lord. In between, I will file all the document of the
Investigation is complete.
Yes, my lord. Charge sheet submitted, my lord. Charge sheet submitted on 10th January 2024, my lord. After 4 years of the FIR, my lord.
But what,
My
how
lord,
will you get out of it?
my lord.
Allegations are there against you.
No, there is no allegation, my lord. I am kindly glance the page number 26, my lord.
Yes.
I am reading the FIR, my lord.
FIR forget. Now come to the statement.
My lord,
Come to the 161 statement, page 31.
My lord.
What is your name? Your name is
This is one of the witness, my lord.
Sitakanta.
My lord.
Yes.
My lord, ମୁଁ ପଢି ଦଉଛି my lord. ଏହି ସମୟରେ ଗୋଟିଏ ଘିଅ ରଙ୍ଗର ଗୋଟିଏ ସାଣ୍ଟ୍ରୋ କାର ଯାହାର ନମ୍ବର MS31CM8978 ଥାନା ଭିତରେ ରଖା ଅଛି ଏବଂ 3 ଜଣ ଲୋକ ଆମ ଥାନା ASI ନାରାୟଣ ମାଝୀ ଥାନା ଭିତରକୁ ଆଣିଲା ଏବଂ ସେମାନଙ୍କୁ ଆମ ଥାନା ଇନଚାର୍ଜ ଗୋଲରୀ ସାର୍ ପାଖକୁ ନେଇଗଲେ ପରେ ଗୋଲରୀ ସାର୍ ପଚରା ଉଚରା କରିବା ପରେ ASI ମାଝୀକୁ କହିଲେ ସେମାନଙ୍କର ଗାଡି କାଗଜ ପତ୍ର ଚେକ୍ କରି ଛାଡି ଦେବା ପାଇଁ କହିଲେ ASI ମାଝୀ ସେମାନଙ୍କୁ ନାମ ପଚାରିବାକୁ କହିଲେ ହସରତ ରାଜପୁତ ଅବରାର ଖାନ ଚକା ସୁନା ଏବଂ ସେମାନଙ୍କ ପାଖରେ କୌଣସି କାଗଜ ପତ୍ର ନଥିବାରୁ ASI ମାଝୀ ସେମାନଙ୍କୁ ଡରା ଧମକା କରି 20,000 ଟଙ୍କା ମାଗିଥିଲା କିନ୍ତୁ ସେମାନଙ୍କ ପାଖରେ 10,000 ଟଙ୍କା ଆକାଉଣ୍ଟରେ ଅଛି କହିବାରୁ ସେ 3 ଜଣଙ୍କ ମଧ୍ୟରୁ ଜଣଙ୍କ ଧରି ହୋମଗାର୍ଡ ସୀତାକାନ୍ତ ପଟ୍ଟନାୟକ ଓ ସୁଶାନ୍ତ କୁମାର ବେହେରା ମିଶି ASI ମାଝୀ କହିବା ମୁତାବକ ଟଙ୍କା କାଢିବା ପାଇଁ ଯାଇଥିଲେ କିନ୍ତୁ ସେଦିନ ଟଙ୍କା କାଢି ନ ପାରିବାରୁ ଥାନାକୁ ଫେରି ଆସିଲେ ତାଙ୍କର ATM କାର୍ଡ ASI ମାଝୀ ରଖି ସେମାନଙ୍କୁ ଗାଡି ସହ ଛାଡିଦେଲେ ଏବଂ ତାର ଆର ଦିନ 20/8/2020 ତାରିଖ ଦିନ 10,000 ଟଙ୍କା ସେଇ ଲୋକ ATM ଟଙ୍କାରୁ କାଢି ନେଲେ ପରେ ମୁଁ ଜାଣିବାକୁ ପାଇଲି ଯେ 3 ଲୋକ my lord. In this case, my lord, neither the present petitioner detained officer, neither they are only they are home guard as per direction of they were taking tea, they were taking samosa, everything they will do as per direction of the officer of the police station, my lord. Only
home guard you don't know. You took the ATM card of the accused person, went and withdraw money and you.
My lord, withdraw my lord, as per direction of the ASI Maji.
These people were detained.
My lord.
And you took the ATM card.
No, ASI Maji took it.
ASI took it. It's all right. You are not so innocent. You are home guard.
Yes, my lord, home guards.
ASI and you, everybody is involved. That it's, don't make it too simple.
My lord, as per direction of the ASI Maji.
How do I?
My lord, that is in the
show me the statement of
yes.
Show me the statement of the inspector.
Yes, that is in page number.
He said that I have asked them to go and.
My lord, but that is page number 27, my lord.
27.
My lord.
ASI is also an accused.
ASI also accused, my lord, in this case. ASI also accused. They are also released on bail, my lord.
Bail is something different.
My lord.
Yes.
My lord, sorry, but page number 28, dear lordship. 28 para 2, Sri H.C. Golari has stated that ASI Maji produced 3 persons, namely Hasrat Rajput, son of Sagar Rajput, Abrar Khan, son of Nahabuddin and Chokasuna before him and told about their suspicious movement in the Naxal affected area, Malkangiri district. Then he inquired with them about their purpose of movement when they were indulging in any illegal activities. Then they told him that they had come to take home their friend vehicle and they did not disclose about their involvement in any criminal activity. Hence, he directed ASI Maji to immediately release the vehicle and person traveling in it after document verification. SI K. Kangana stated that he has seen one ghee-colored Hyundai Sentra vehicle part inside the Mudlipada PS permission, 3 persons being brought to police station by ASI Narayan Maji. Then I have examined CSP owner Chittaranjan Patnaik, who has stated that 4 persons, including 2 staffs from Mudlipada PS, had come to his CSP in the night, that is 19th August 2022, to his CSP and had asked for withdrawal rupees 10,000 from his CSP. But it was late night. He was not having sufficient care. He could not provide. Again, 2 staff from Mudlipada PS had come to CSP on the afternoon 20/2020 and have withdrawn rupees 10,000 after swapping ATM and entering PIN.
Then what do you want? You are reading statement against you only.
My,
all these things are there, sir.
That comes against the ASI Maji only, my lord.
How you, what are you talking? You read simple English which everybody can understand. And you know that.
My lord,
I don't.
again two step, my lord, against two step, that is, I think, my lord, against two step from Madhulipura PS, my lord, my humble.
Argue on this point.
My lord, 1 point I want to submit, madam. 1 point, madam. The Malkanagiri PS case number 289 of 2020. In that case, Istekar Khalid, Ajit Rana, Haridas Biswas, Intejar Qureshi, and Hasrat Rajput, Abrar Khan, they arrested in the on that
NDPS case.
That NDPS case.
Right.
But in that NDPS case, they have not charge sheeted the present two petitioners. They have not charge sheeted. If they help the accused person.
So see, however, and all these things has to be tested in the trial only.
A clean case without against you.
No. Yes, I want to submit.
Madam, for the petitioner seeks to withdraw this petition to raise all the point before the court below at the appropriate stage with this liberty the petition is disposed.
May I pray the one thing, madam? I will submit some citation, madam.
But citation facts are so clear. What citation? Unnecessary wasting time. I have given liberty.
Requested me to seek and pass over your lordship. May I make a small prayer, lordship? Can this matter be taken up at 2 p.m. lordship? It's
Pass over 2 p.m. only.
Lordship. Obliged, lordship.
24.
Yes.
May I please, your lordship?
Yes.
Initially, FIR was registered on 376, 511 IPC and 12 of POCSO Act. Thereafter, charge sheet was filed under section
239 petition has been rejected by the court below.
Let's see, what are the allegations against you?
FIR
rejection order.
I know what is the allegation against you. 498. Let counsel for the petitioner seeks time to file additional document to substantive the case. One which time is granted. File the.
Yes, madam.
Yes.
26.
Similar matter, my lord, has been pleased to issue notice. 7 years, 10 years here again pending.
I have corrected your lordship's order and given the correct numbers.
Cognizance of case 39.
That was 2013, this is 2017.
কিন্তু FIR sorry charge sheet file ହେଇଛି 28/10/2012 12 5 ବର୍ଷ ପରେ ନେଲେ cognizance. Your lordship may look at page 39.
What do you want then?
Delay issue notice, your lordship. Without hearing, obviously, my lord may not be.
Instruction.
Sir, this is not my case now. I had a matter day before yesterday. The other side took time on account of her demise of her father, and I was praying. I'm suffering the stay for last many years now because of this. Only thing is
there is a bereavement, so what to do?
No, I am not on that. I quite agree. I had also bereavement last week, my lord. Unfortunately, case is posted to August. I'll make a mention, your lordship may prepone it to June sometimes because may
move some application.
I'll move
an application. Yes.
I'll mention it.
Move an application, that's better. Because the other side will also get an opportunity to see. Yes.
27.
Please, your lordship. Petitioner has challenged the question of entire proceeding, my lord.
on the ground of Lord delay in completion of the trial, my lord. My humble submission, Lord, trial has not yet been commenced. FR of the year 2000, my lord, charge sheet has been submitted on 16/7/2002. My lord, cognizance has been taken on in the year 2009, my lord. And the charge has been paid.
What are the offenses?
My lord,
Prevention of corruption.
it's my lord,
Let him complete.
13-2.
Delay attributed to accused
13(1)(d) and 120(b).
Listen to him.
Delay attributed to the accused persons.
Then
Your lordship
Where?
kindly
so
see.
if you have caused delay, how can you take
Your lordship see page 109.
109?
21/12/2022 ରେ ଲର୍ଡସିପ got it.
109.
Hello.
Yes.
21/12/2022 ରେ only charge was framed.
21/12?
2022. Prior to that, there are so many applications before this honorable court. Still now, also pending applications are pending on at the behest of the co-accused persons.
Where is that?
If they will not, your charge sheet says, your lordship kindly see, the entire order sheet they have annexed. Your lordship see, some way or other pretest, they are adjourning the matter. They are not appearing. How charge will be framed?
Where? I filed the entire record.
Accused ଅଛନ୍ତି, including on minister.
Nine accused persons are there, my lord. Case of the year 2000, my lord. And now 2004, my lord. I am a poor junior engineer, my lord.
A petitioner.
Again of my service.
A petitioner is agreed by the delay in completion of trial. The
I was relayed, my lord.
FIR was registered in the year 2000. FIR was registered against the petitioner and 8 other accused persons on 30/9/2000 under section 13(2) and 13(1)(d) of PC Act, trade with section 120B. 120B
of the IPC.
The charge sheet was filed on
My lord, 16/7/2002.
16/7/2002, and the cognizance was taken. Cognizance of the offence was taken on
2009.
1/8/2009.
1/8/2009. Subsequently, the charges were also framed.
On 21/12/2022.
On 21/12/2022. Why? Mr. Maharana, learned counsel for the petitioner, opposite parties submits that delay is attributable to the accused persons. Since there are 9 accused persons, the delay, 9 accused persons, and at the instance of accused persons, many proceedings were initiated before this court. Which is a attributable cause for delay in the proceeding. Having said that, I am of the considered view that every accused has a constitutional right for free, fair, and speedy trial. Since the case is pertaining to the year 2000, the trial court is directed to do well to see that the trial is concluded as expeditiously as possible. With this observation, the petition is disposed. Yes. Next.
28.
Lord, you may say, Lord, 6 months or.
I don't know how many accused. You once I say 6 months, again application will come. For
I'm relying that, Lord, Vakil Prasad Singh, Lord.
That is the reason I have said that you have a constitutional right.
Yes, Lord. 21.
Enough, I think it's enough indication to the trial court to do well. You see, yes.
Belgium matter copy of this order may also be intimated to the lower court, so that
Copy of this order may be communicated to the trial court. Yes. Next.
28,
Yes.
my lord. It's a Belgium matter, otherwise, my lord.
Yes. When you got the bail, sir?
My lord, in 2015, I have got the bail. My lord, this is in the charge sheet.
Item number?
28. 28, your lord.
2015.
Yes.
You got bail 2015.
30/5/2015.
30/5/2015. NBW?
18/4/18.
18/4/18.
Yes.
Ketti ron option?
18.
Pay 1,000.
You lord, please.
1,000. Yes.
29.
My pleasure, Lord. Here, my lord, petitioner is implicated in a case under section 13(2) read with 31(c)(d) of PC Act, read with 409 and 120B of
IPC, my lord,
Yes.
with an allegation that some amount has been misappropriated while she was the Gram Panchayat technical assistant, my lord. And subsequently, he was released on anticipatory bail, Annexure 3, my lord. In the event of arrest, my lord, shall be released on bail. And now charge sheet has been filed, and now, my lord, cognizance has been taken, and matter has been posted for appearance, my lord. So I may be allowed to go on bail so that I'll.
You are already on bail.
In the event of arrest, that is.
In view of that, Mehbud Baba and CBI, last day before yesterday, your lordship has passed.
Susila Agrawal and.
No, Susila Agrawal.
That is, my lord,
Mehbud Baba and versus CBI.
Then comes for the petitioner submits that he was. Where is that order?
Annexure, my lord, 3, page, my lord, 31. Start.
At the stage of investigation, at the stage of investigation.
Yes, my lord.
At the stage of investigation, he approached this court by filing ABPL number 10424 of 2019. 29. This court, by order dated 31/7/2019, have enlarged the extended the concession of pre-arrest bail, and directed that the petitioner shall be released on bail. Where is that? That if he sent up.
Page 32, my lord, bottom portion. Hence, the consideration. Submission code directed in the event of arrest. The petition
last para.
Directed that in the event of the petitioner being arrested by the police, he shall be released on bail. Released on bail. Now the next paragraph. The charge sheet has been filed and
showing not arrested.
Charge sheet has been filed showing the petitioner
not arrested.
Not arrested, and thereafter by order dated 8/1/2024, cognizance of offence under section 13(2), read with section 13(1) C and D PC Act, trade with section 409/120B IPC has been taken against the petitioner. Counsel for the petitioner seeks to withdraw this petition to appear before the court on or before 30th of May 2024 and seek remedy under law. He further submits that in view of
Mehbud Baba versus CBI 2023 online.
And also, my lord, that no, my lord, that Siddharam long. That this one.
Once
yes, my lord. Once bail, a lordship is there.
He would move application before the trial court. In the event he moves such application, the same shall be considered in the light of the judgment of the Supreme Court and Supra. Yes.
Released on bail on such terms and conditions. As in
that's what I'm saying. I'll not fix the conditions here. Yes.
30.
Yes.
My lord, I'm challenging cognizance order, my lord. Page 19.
90.
19, my lord.
19, yes.
Annexure 3.
Yes.
We are the revenue inspector and police constable.
Yes.
Went for demarcating of the land as per the direction of the Tahsildar. The IIC instructed me also to join there for peace and tranquility.
Yes.
We went there. But OP number 2 initiated a case, complaint case before the court below, in which the court below took cognizance against us.
What are the allegations against you?
My lord,
complaint.
Page 13 and 14, the direction to accompany with the Tahsildar.
Forget it. What have you done? After direction, you went there.
My lord.
What have you done? That is the relevant.
The allegation like that we assaulted to the.
Then
202, 200 initial 202.
Then if the allegations are assault and all, merely you have gone on the instruction of your senior officer, will not exonerate you. Senior officer told you go and beat them.
My lord. No, my lord. They have not started so. We went with the Tahsildar. And as per the direction of the IIC.
You are challenging the cognizance. See the offences.
Offences, my lord.
One CC case was filed against you.
My lord.
And there are allegations are made against you. How will I go into all this?
Here
question
the
whether-
file manner the statement they recorded under section 200 and 202 manner. They
Yes,
have not
I-
given.
that's what I
They are only manner the whether that is allowed or
What to
not.
do?
That I have also, I will supply the same manual after getting the certified copy of 200.
What will I do? Certificate copy. See, come to the allegation part.
Allegation part,
Come
my
to
lord.
the allegation part at page
Allegation page 17, my lord.
17. Read it out.
My lord.
Read it out.
ଉକ୍ତ ଦିବସ ଉକ୍ତ ସମୟ ଶୁକ୍ରବାର ନମାଜ ବାରିଥିବା ବେଳେ ଆମେ ମୁଦେଲେଙ୍କ ପିଲାଛୁଆ ଓ ଭାଇଆର ନମାଜ ପଢିବାକୁ ଯାଇଥିବା ବେଳେ ମୁସଲମାନ ମୁଦାଲା ମାନେ ଜୋର ଜବରଣ ଆମର ଦଖଲି ଉକ୍ତ ସମ୍ପତ୍ତିକୁ ପ୍ରବେଶ କରି ସିମେଣ୍ଟ ଖୁଣ୍ଟ ପୋଡି ବାଉଁଶ ଦ୍ୱାରା ଘେରି ନାଲି ପତାକା ମାରିବା ବେଳେ ଆମେ ମୁଦେଇ ଘରେ ଏକୁଟିଆ ଥିବା ବେଳେ 1 ନମ୍ବର ମୁଦାଲାଙ୍କ ମୋ ଜମିର ଅଦାଲତ ମୋକଦ୍ଦମା ଚାଲୁଥିବା ବେଳେ ଆପଣ ବାଡ ବୁଝିବାକୁ କିଏ ପଚାରିବାରୁ 1 ନମ୍ବର ଓ 4 ନମ୍ବର ମୁଦାଲାଙ୍କ ନିର୍ଦ୍ଦେଶରେ ଅନ୍ୟ ମୁଦାଲା ମାନେ ଜୋର ଜବରଦସ୍ତି ପଶି ଆମର ଦଖଲ ଜାଗାରେ ସିମେଣ୍ଟ ଖୁଣ୍ଟ ପୋଡି ପୋତି ବାଡ ଦେବାକୁ ଆମ୍ଭେ ବିରୋଧ କରିବାରୁ ହଠାତ୍ ଉତ୍କ୍ଷିପ୍ତ ହୋଇ 1 ନମ୍ବର ମୁଦାଲା ଆମର ଡାହାଣ ଗାଲକୁ ଶକ୍ତ ମୁଥା ମାରିବାରୁ ଆମେ ମୁଦେଇ ଡାହାଣ କଳ ଦାନ୍ତ ଭାଙ୍ଗି ଯାଇଥିଲା, ଉପର ଦାନ୍ତ ହଲୁଥିଲା। ଆମେ ମୁଦାଲାକୁ 1 ନମ୍ବର ମୁଦାଲା ବିଧା ଚାପୁଡା ଗୋଇଠା ମାରିବା ଦ୍ୱାରା ଆମେ ତଳି ପଡିଯିବାରୁ ଅନ୍ୟ ମୁଦାଲା ମାନେ ଆମ୍ଭେ ମୁଦେଇକୁ ବିଧା ଚାପୁଡା ଗୋଇଠା ମାଡ ମାରି ଆମ ଶରୀରରେ ବ୍ୟଥା ଉପୁଜାଇଥିଲେ। 4 ନମ୍ବର ମୁଦାଲା ଧମକ ଦେଇ କହିଥିଲେ କି ବୁଢା ନାମରେ ମିଥ୍ୟା କେସ୍ କରି
All these things you have done because your senior told you to do.
Police was there. Police was there. Tahsildar was there. Tahsildar was able
How
to
do I
act
know? This is at a cognizant stage. I can't go into all these things.
without
Whether
sanction.
you
My
are
lord, the
beaten,
copy
or
has
not
been
beaten,
taken.
what are the medical evidence? What are the statements?
No, my lord, no medical has
I
been
don't
given
know.
by-
I don't know. The cognizant stage, I can't get into all these things.
There is sanction- lack of sanction, my lord.
Withdraw this petition to raise all the points before the court below at the appropriate stage. With this liberty, the petition is disposed. Sanction and every point you can take there. I know.
31.
31, my lord. Yes, my limited grievance, my lord. Annexure was the impugned order wherein the court below has allowed for release of my vehicle, my lord. I am the registered of the owner, my lord.
Yes.
In page 12, let's may kindly have a glance. Clause number 2, the petitioner shall produce a valuation report of the vehicle by an approved valuer, my lord. That I have already produced before the court below relating to other conditions, my lord. What happened, my
Your
lord?
application on 457 is allowed.
Allowed.
Allowed with a condition.
Condition.
You are agreed by the condition.
Element condition that I, along with other condition, I will submit a report from the valuer, my lord. That valuer report, page 16,
Yes.
that is a discrepancy in my engine number for which the court below is not releasing, my lord.
Take another valuation report. One.
No, that cannot be, my lord. What he has written, my lord, also I am reading, B. The
I
actual.
will give you an opportunity to get a fresh valuation report.
No, that cannot be done here. What I am saying, my lord, I will give a undertaking before the court below, the engine number which reflected in the valuation.
Why can't you take a fresh valuation report?
Valuation report, it will not suffice, my lord, because I am reading, last me see, there is a typographical error. The actual engine number is so and so as marked in the specification plate engine number of vehicle. Further, as per the data based on the Tata Motor online system.
Who has given this valuation report?
That Pramod Kumar Sahu, the page 16, my lord. He has given, there is
a private valuer. Why can't he give a fresh one correcting the numbers and all?
Because that number discrepancy is always there in my registration certificate and in the engine, my lord. When the registered certificate has been issued by the RTO, he has inadvertently not mentioned 4 number. That he has already written there. Let's see the last paragraph. It is worthwhile to mention here that the last, the 6 digit.
Which paragraph you are reading?
That is page 16, B.
One.
B, the second paragraph. Third paragraph.
16,
It is worthwhile to mention here that last 6 digit, that is so and so stated for the serial number of the engine. So other particulars are mentioned according to the engine says so Tata Motor Limited, last 6 number match which RC particular specification plate. It is considered opinion that the engine number fitted vehicle, register number is a genuine one. But he has, from the first paragraph, it is written that I opine to be typographical error in my end of the RT official. So RT official has,
Yes,
so
that is
I am my similar order.
I am. Yeah,
I will
this
give.
is the inherent mistake already committed by the RTO. What will you do?
My lord, the
I'll say,
lordship, my lord, the direct the court below to call for a report from the IO. And
No, I am not saying, I am not there.
RTO and IO, my lord.
I am.
Through IO, call for a report from the RTO and send the court and court verify.
That is true, my lord.
Release, my lord.
Similar circumstances, this court has granted, I have filed an undertaking there that I will not change the nature and character of the vehicle. I will, as and when required, I will produce. On that undertaking, it has been allowed.
Report मागियो आती हो
हाँ,
through IAC.
I will also file undertake.
सही ये dispose कर दे.
हाँ, that I.
Trial court will मतलब dual.
That I am not.
I'll set aside it. I'll set aside the order. Trial court. And I'll ask you, I'll allow you to move press application and give undertaking.
Given that I will suffice, my lord.
The petitioner is agreed by the order dated 23/2/2024 passed by the Court of JMFC Burville.
Yes, ma'am.
Burville in CMC number 9 of 2024, whereby his application under section 457 CRPC has been allowed conditionally. He is agreed by the condition. Which condition?
Two.
He is agreed by the condition that he shall produce the valuation report of the vehicle by an approved valuer. When approved valuer. Next paragraph. When the petitioner approached the approved valuer, the valuer had given a report inter alia stating as under. ये page 16 रे 8 लिख दो. B page 16 रे B A B और C B लिख दो. ठीक है? B लिख दो. Then counsel petitioner submits that there is a inherent mistake in the number of the chassis. Inherent mistake in the chassis number.
Engine number.
Engine number entered by the RTO. Therefore, the valuer cannot correct the valuation report submitted by him in full stop. What is this judgment?
That is judgment. That is a similar circumstance that chassis number has discrepancy. My lord has directed that I am not waiving the condition. I am directing you file an undertaking that you will not change the character and.
Counsel for the petitioner submits that there is a in the similar he submits that he would furnish what would you furnish?
Undertaking.
He would furnish an undertaking owing to the fact that there is a discrepancy in the engine number. He further submits that he would be moving the application before the court below, inter alia praying to accept the valuation report submitted by the submitted by the valuer on 7/3/2024 and furnish undertaking accordingly. The petition is partly allowed with a direction to the petitioner to move appropriate application to the court below. If such application is moved, the same shall be considered in the light of the order passed by the coordinate bench dated 26/8/2022 in CRLMC number 2114 of 2022. Partly allowed. Yes.
There is a discrepancy in engine number. Same, both of them.
In the light of this. Yes. 33.
Lordship.
Yes.
Last occasion, Lordship director appeared the accused person. Lordship may take it up on to 2 p.m.
They are there.
Lordship.
This one not there.
Accused
Accused does not come today. We come at 2 p.m. Lordship,
You can bring na. Okay. 2 p.m. No problem.
Lordship. Okay.
34.
Yes. 34.
May I please your lords?
Yes.
Page 81 may kindly be seen.
8-1.
8, my lord. That is under challenge.
8-1.
My lord, 8-1.
Acha. Yes. 8-1.
So far as only this
Yes.
Karta Bahini Pati is concerned.
Yes, sir.
NBW challenge.
NBW.
Yes.
Cancel it. What?
No. NBW is a bail he not line, but bail jump no.
No, absconded.
तो ठीक है आप
On the prayer of IO, NBW issue.
ऑफेंस कौन
384.
395, 397.
384.
395, 397.
Charge sheet से
The petitioner is agreed by the order dated 23/10/2019, whereby the SDJM CTR has issued NBW against the petitioner. Petitioner in which case? In
Chakkakhandi PS case number. Chamakhandi.
In GR case number 307 of 2018. 20 in corresponding to Chakkakhandi PS case number 92 of 2018. Petitioner was stated to be absconding.
Yes.
Therefore, the charge sheet was filed showing him as an
absconding.
At the request of the IO of the case, the trial court has issued the NBW against the petitioner.
Dated 23/10/2019.
On
23/10/2019.
Petitioner is agreed by the same order and seek indulgence of this court. Laid out. On instruction, petitioner submits that counsel for the petitioner submits that the petitioner would appear before the court on or before 30th May 2024 and move appropriate application under law. Application under law. With the aforementioned.
May I pray, my lord? In fact, practically the charge sheet has been challenged by us. That is why let them take instruction, let them say why it is all not.
You have not surrendered nothing. How can I?
Yes, may kindly see.
No, if I surrender, they will not release me on bail.
That's a different story.
That is why practically the prayer is that
practical difficulty, but how can
charge sheet is
if you are absconder? I will not.
I have given everything. Let them
Then
say
you
that
surrender.
yes.
I'll keep it pending. You surrender. Then I'll.
Lordship, may kindly see the prayer. Prayer, your lordship, may kindly.
I have seen. अरे देखिए जी मुझे कहीं से कथा कहूँ बट practical ये छुआ पिलाटे से करी पारिनी अब कौन तुम से तेरे
ସେଥିପାଇଁ ଆପଣ ଆଉ କଣ observation ଦରକାର ହେଲା I give it.
Anticipatory bail file करते सेटा भी.
Let them say that the charge sheet supports the case. I have given the entire charge sheet.
That is why.
आज ही कोई दल पढ़ी गिरी कौन?
You are an absconder. I can't. Anticipatory bail is rejected. You challenge the charge sheet. You are absconder. What is?
I am ready, my lord. I have gone through all these documents.
All others are on bail.
I'll write that.
And
Parity.
first hour, second hour.
On the ground of parity, you will see.
Parity and first hour, second hour. Otherwise,
both the courts.
First hour, second hour, and the same day.
If such application is moved, the same shall be considered on its own merit. Let it for the petitioner further submits that all the questions have already been granted bail.
Yes.
Therefore, he is entitled for bail on the ground of parity. On the ground of parity and apart from merits. Apart from merits. If such application is moved, the same shall be considered on the same day.
Both the courts shall
By both the courts.
Same day
dispose on the same day.
on the same day.
Madam.
That is the best thing. Why?
My lord.
35.
May I please? Here the matter relates, the matter relates to adducing of defense evidence. My lord, may kindly turn to page.
Defense evidence.
Yes, ma'am.
Who are you?
I am the accused in a complaint case under section 138 of the NIA.
My lord, today I appear for the complainant, my lord. I am also filing my objection. This is a 2009 matter. Both two accused persons The check bears the signature of two accused persons. And both the accused persons admit their signature. One accused person admit that we have evidence was recorded in 2012. One accused person say that we are jointly liable for the amount in question. Now the matter is being protracted and delayed from time to time on some pretext or other by the petitioner, unfortunately.
Right.
I am filing my objection. Your lordship may hear it
No.
any day.
Then what does he want then?
What happened?
Yes, my case.
It is already delay. Why do you delay? On this material, if I can dispose it upon, dispose it.
My lord, why I am saying, my lord, there are a lot of document orders passed by this.
What is the check amount by this? What is the check amount?
No, that is 32 lakhs. Well, let me place my case. If I don't have any case, my lord may reject it.
Right.
My lord may
Why am I saying? I am filing my objection, my lord.
I'll take it right now.
Yes, ma'am.
Yes.
My lord may kind down to page 28.
28? Yes.
Look, this is an application filed by the present opposite party number 2, that is the complainant in the court below, to call for the records from the State Bank of India regarding opening of the joint account, which I and the OP number 1 holds. Well, that was allowed. My lord may kindly now turn to page 4 of my petition.
Yes. Yes. Thereafter what happened?
Well, that was allowed. Well, accordingly, the present opposite the complainant took necessary steps for compliance of that order. Well, subsequently, well, there was a settlement between the accused number 1 and the present complainant. So they filed an application not to proceed with that order regarding implementation of to call for the records from the branch manager. Well, that was rejected by the land court below. Since I don't have any power to recall, so this order has to be implemented. So accordingly, well, that application filed by the complainant was rejected. Well, thereafter, another application was filed by me, filed by the complainant on 15/5/2024. Well, that is in consonance with the order dated 11/12/2022 to again call for the to issue necessary coercive steps so that the branch manager can produce all those bank documents. Well, since that no steps were taken by the court below, so I came before this honorable court by filing a criminal miscase. And what order was passed, my lord, may kindly see Annexure 5, page 31.
Yes.
My lord, may kindly relieve it. Order starts from page 33. Hard land counsel for the petitioner, non-appears for the opposite party. The petitioner accused number 2 in the court below has filed this application under section 482 of CRPC, challenging the inaction of the land JMFC Bhubaneswar in not disposing of the application made by the complainant on 15/5/2014 to comply with its order dated 11/12/2012 and 24/11/2016 passed in 1CC case number so with regard to production of certain documents by the branch manager SBI Industrial Estate Branch Rasulgarh Bhubaneswar. Now my lord, page 34, next page. Operative portion of the needless to say that when an order is passed by the court, it must see that its order is complied with and is required to take coercive steps against the person who has not complied with the said order. The learned PU appears to have not adhered to the same in this case. Therefore, this court hopes and trusts that the trial court shall do well to see that its order for summoning the aforesaid witness and production of the document is complied with. If at all the complainant does not want to adduce the same as evidence, the court, however, is not bereft of jurisdiction not to insist upon the same. But it must give reasonable opportunity to the petitioner. The petitioner means present petitioner that accused number 2. To adduce the same in its defense by calling for the documents from the bank concerned, or in alternative, the petitioner files the certified copy of the documents to admit the same into evidence without insisting the original or the same is permissible under the Bankers Books Evidence Act 1891. However, reasonable opportunity in this regard must be given to adduce the same as defense evidence if the court recalls its earlier order for production of the said documents. In the meanwhile, if the petitioner applies for certified copy of the documents in question to the bank concerned, the said bank shall supply the same within 15 days of receipt of the said application, or else the court shall call for the same at the instance of the present petitioner. So there are two directions to me.
Get the certified copy, place it.
Place it. The second alternative is if documents are not supplied, so I have to file an application for the court below so that court can insist for production. Now, my lord, can see there are page 74.
You moved the application.
Yes, this is my lord.
Have you applied for certified copy?
Yes, page 74 left side top, my lord, this is 3rd of March 2020. This was submitted to the branch manager, SBI Industrial Branch, to supply the documents.
Yes.
Well, that was not supplied. So accordingly, I filed an application on 29/2022 because COVID came in the meantime. So 2022 page 36 is my application.
Page 36, okay.
Yes, 36 annexure 6.
Yes.
My lord,
Which is rejected now.
yes, now that this is rejected. Now, what are the grounds, my lord, page 37, paragraph 4. That further in obedience to the order dated 13/1/2020.
Yes, I understood it. Now, where is the order?
Order, my lord, may kindly see annexure 11.
My lord, before that also.
One minute, sir. Let me understand. Let me catch the fact.
Annexure 11, page 89.
You are agreed by this?
No, prior to this, my lord, this application, when I filed this application for the law and trial court for compliance of my lord's order, my lord, the opposite party approached this honorable court by filing an IA for recall of that order. My lord, we can see this IA starts at page 39.
What happened to that recall order?
Well, that was rejected.
That order became final.
That 13/1/2020 order became final.
That is
my lord,
complied now.
Yes. Now,
That
my
has to be
lord,
complied now.
yes. Now, what has held the law and trial court, my lord, may kindly see. Well, he has proceeded further. Well, actually, this order amounts to contemptuous.
Well,
Yes.
which is the order you are now agreed?
Well, 16/12/2023, it starts from page 89. Annexure 11.
By way of this order, your application is rejected. Yes.
And what are the grounds, my lord, may kindly?
Yes.
It starts at page 93. After giving thoughtful consideration to the submissions for both the parties, this court went through the materials on case record and also poured over the orders of the Honorable Court passed in CRLMC number 2855 of 2019 and IA number 2236 of 2020, arising out of CRLMC number 2855 of 2019. The operative part of the order dated 13/1/2020 of Honorable High Court of Orissa passed in CRLMC number runs as follows. I have placed this
modified by the Honorable Court. What is the modification order?
Well, it has never been modified, my lord. Can see.
The operative part of the order is there. It is reproduced.
Yes,
94.
I have placed that.
In the result, IA stands disposed of with a direction to the so to consider and pass the appropriate order with regard to the application dated 20th September 22 filed and so on merit without being influenced by any observation made therein above, and also to expedite the hearing of the disposal of the complaint proceeding at the earliest, preferably within a period of 4 months from the date of receipt or so on so. Yes, this is the modification.
No, this honorable court has never modified. My lord, can see the
IA without influence by the observation.
No, my lord, can see. It's IA. Page 77. Order passed in IA.
What is that?
Page 77.
77. Yes.
Order dated 12/12/2022 in IA number 2236 of 2022. Instant IA at the behest of paragraph 2. Instant IA is at the behest of OP number 2, namely the complainant in Vanchis case number so filed under section 138 NI pending before the court of law and JMSC Bhubaneswar with a prayer.
Yes.
To recall the order dated 13 January 2020 passed in.
Come to the operating part.
Yes. My lord, get on to paragraph 10. The paragraph 6 is the
order.
Yes, the court perused the order of this court dated 13 January 2020. All facts related to the dispute involving the parties have been brought to the notice of the court, including the fact that such an application was moved by the opposite party number 2 and subsequently it was not pressed. But still the court further proceeded to hold that if such action of the land court below was pending compliance or it could not be complied with, notwithstanding the fact that opposite party number 2 did not want to adduce any such evidence. Further observe that under such peculiar facts and circumstances of the case, reasonable opportunities should however be granted to the petitioner to adduce evidence by calling the documents from the bank, or in the alternative, if any such certified copies of the documents are produced, the same shall be admitted without insisting upon production of the originals as permitted under the provision of Bankers Book Evidence Act. Now, my lord, paragraph 10. At page 80, relevant portion at page 81, 11th line from top. Line starts with in the present.
Right.
In the present, admittedly, opposite party number 2 had not entered appearance in CRLMC number so and so, which are disposed of at the stage of admission, but even by such an order, opposite party number 2 is not prejudiced
as all the facts related to the dispute were placed on record, including the fact that opposite party number 2 did not raise the matter or intended to bring the bank documents before the land court below as originally applied for, and was drawn to the notice of the court, which ultimately, considering the same, passed the order dated 13 January 2020. It is not that the petitioner suppressed any such facts with regard to the application removed by the opposite party number
Give
2.
the objection. What do you say?
Right. This court rather confirm the order dated 31/2020 so that I should be given a reasonable opportunity to adduce.
Why the bank is not giving certified copy?
My lord, I am coming to that part, my lord.
Yes.
Here, my lord, what happened in this case, my lord? The background is very important, my lord. I have also given all the documents.
No, there is an order.
There is an order, my lord.
This court.
Before coming to that part, my lord, I would like to bring your notice why I applied for the document under section 91 CRPC. Here, what happened, my lord, the two accused persons, as I said earlier, my lord, two accused persons, they signed the check. Accused number 1 admit, both the accused persons admit their signature. One of the accused persons also admit that we are jointly liable. And while giving
When need
evidence,
to go into all these things. See, there is
no, my lord,
the simple
during
order
the-
is
well, why?
he wants some document to be produced.
I am coming to that part, madam. And in the impugned order, which is under challenge here, there the trial court has discussed everything. Nothing has been it has already discussed. I am coming to that part, my lord. The accused number 2, the present petitioner, in his evidence, though admit his signature, he said that I do not know the complainant. Then I file during the course of the evidence also I have given.
Yes.
Then I filed an application under section 91 of the CRPC to call for the opening form for opening of the account, joint account, opened in the name of both the accused person, petitioner and the opposite party number 1. That was because I was the introducer to that account. So his plea that I do not know the complainant, for that reason I filed application under section 91 in 2014. That was allowed. Then subsequently someone was issued, but for reason best known, the bank didn't turn up and filed the
So ultimately, the bank's evidence is so essential. That is what the court says that
no, my lord, what happened there then, in the process, 4 years passed. Then I filed an application in the bank, and on the basis of my application, they produced the document which shows that this Sanjeev Mahanti, the petition number, the opposite party number 2, is the introducer to that bank. So his plea that I do not know the complainant, that is not correct. Now, my lord, what happened during the pendency of this case? I filed that application before the trial.
No, you see what you are trying to say. What you are trying to say is the document he is interested to bring on record.
He has not
relevant document. That's
my
what
lord,
you want to say.
the interesting part is he has never filed any application at any stage. He filed an application that the action should be taken as the bank manager for not producing the document. That is the only application he filed during the trial.
See, this
That was rejected. My lord, that was rejected.
Direction. That has to be complied.
No, my lord, that was rejected. Against that, he preferred CRLMC. That was withdrawn. Then he filed this CRLMC 2855 of 2019. There, his prayer is that the application pending, my application, that should be complied with. And that was disposed of at the stage of admission, my lord. That was disposed of.
That was in your absence, it was done. Then you moved an application for modification.
Modification.
And
Then
that,
your lordship.
that was also
No, my lord. Your lordship, in the order, modification order,
Para 12.
subsequent order, page, your lordship may come to page 80.
80.
Yes.
Yes.
Mr. Mahanti, Learned Counsel for the opposite party number 2 submits that the compliance ought to have been in respect of the specified record which are originally been applied for from the bank. But the petitioner has included more documents which are never intended by the opposite party number 2. While pressing the requisition, in any view of the matter, the court is of the view that such an application which is pending before the learned court below under Annexure 1 shall be examined and order to be passed thereon on merits, and therefore it should be better left to the discretion
That
of the
is your
court
submission.
concerned. The discretion was left to the tolerant court below.
No, that was submission.
No, my lord. That is the view of the, it shall be examined.
Court is of the view.
In any view of the matter, the court is of the view. This honorable court's order, my lord. That such an application which is pending before the learned court below under Annexure 1 shall be examined and order to be passed thereon on merits, and therefore it should be better left to the discretion of the court concerned. Then your lordship may turn to, which your lordship has already seen, keeping in view that the matter is pending since 2009 and it is being adjourned from time to time by the petitioner. There the lordship said, in the result, I stand disposed of with a direction to the learned James Bhubaneswar to consider and pass appropriate orders with regard to the application dated 20th September 2022 filed in 1cc number so-and-so on merit without being influenced by any of the observation made herein above, and also to expedite the hearing and disposal of the complaint proceeding at the earliest, preferably within a period of 4 months.
Therefore, the page.
Then, my lord, then
1 minute. The page
yes, madam.
80 observation which you have pointed out.
Yes, madam.
The court says that don't go by that observation, independently decide.
Yes, madam.
So the earlier order stands.
Earlier, my lord, earlier order that this, so far the documents are concerned, there this court observed that it is at the discretion of the court on
But
merit.
at
You
the
will
same time, this court says that don't go by my observation in this order. What to do?
and paragraph 8, my lord, I placed paragraph 8 again, my lord. May I place it
I
again?
read it. You read it out. I understood it. But at the same time, in the ultimate paragraph, he says that don't go by my observation.
Then your lordship may see the impugn order, which my learned friend is referring to.
Where is the input?
This order is in
Where is
final
the-
set of this honorable court's order.
Let me place it. You have already placed
Yes, sir. Impugn order, page 36.
Impugn order starts at page 89. Next one.
And another aspect before coming to the impugn order, my lord, the order was passed on 13/1/2020.
Because of your this fighting,
No,
only
my
the
lord.
matter is not
13
proceeding.
no, my
It
lord.
should have been done within 6 months.
My lord,
What is this?
13/1/2020, the matter, the order was passed by this honorable court, which my learned friend was referring to. He placed it 2 years after and taking the plea of Corona. But if his bona fide intention is apparent from his conduct,
Have
that
you moved
order was
application?
passed.
Have you moved application under 143(3)?
No, my lord. 13/1/2020. The
I'm
order
saying
was.
something
I am not on that part, my lord.
Why you moved application? Get
I am
someone-
not agreed, my lord. I am not agreed, my lord. The trial court has considered everything and finally said that the petitioner has never filed any application to call for the record. That is the interesting part. And trial court ultimately held.
Which part of the impugn order?
Yes, my lord. Good idea. This is limited into. My lord, the para 10, my lord.
Yes.
The honorable court are deeply concerned about the increasing number of NI cases in the docks of so and so, so and so. As a sequel of our discussion, the court is of a humble opinion. There is no necessity to summon the bank manager, SBI Rasulgarh branch, to produce relevant documents about the details of the joint current account, which stands in the name of both the accused persons, wherein the present complainant Sanjeev Mahanti has signed in the account opening form as introducer. Because those documents are already on record being filed by the complainant, which he often threw RTA from the said banks. Allowing the prayer of the accused petitioner would be nothing but would be a futile exercise of jurisdiction, wasting the time of money, power, and so on. So, my lord. My lord, it here also, page 95, para 9. By order dated 11/12/2012, the then JMFC Bhubaneswar allowed the prayer made under section 91 CRPC by the complainant with a prayer to issue summons to the bank manager SBI also to produce relevant documents about the details of the joint current account number so and so, which stands in the name of both the accused persons, wherein the present complainant Sanjeev Mahanti has signed in the account opening form as introducer for the purpose of testing the veracity of evidence led by the accused number 2 in his evidence. In spite of repeated summons, the bank manager SBI did not produce the relevant documents, as a result of which the further proceeding in the case was stagnated. Finding no other way out, the complainant made an application for those relevant documents through RTI Act and made a prayer to this court not to place the previous order passed by the then JMFC Bhubaneswar on 11/12/2012. But the same was rejected. However, after obtaining those relevant documents under the RTI Act, complainant produced the same in the court on 15/1/2018. Hence, there is no necessity to linger the case to carry out the order of the then JMFC Bhubaneswar passed on 11/12/2012. On the other side, the accused person have not assigned any reason to the satisfaction of the court that in which way they will be prejudiced if the above mentioned order is not carried out. Rather, the conduct of the accused clearly shows that he has the tendency to procrastinate the trial for years together on some pretext or other, which is disclosed from the case record.
Okay, I will pass the order.
Then, my lord,
Since the order dated 15th January 2020 has actually.
This is a 138 case. How many years you will pull on?
No, I don't have.
Unnecessary.
Well, your lordship may kindly.
my lord, another aspect, my lord, if your lordship permit me, then I will previous orders of this court also I will.
See, am I deciding the matter finally? This is he wants to produce some document. You have already got those document.
My lord,
you
my lord, my lord, even
this is the only
wait a
way.
minute. My lord, even I don't want.
How many times you have come to High Court? This is a 138 matter.
My lord, he came and.
Anyway, I'll take note of everything.
My lord, my lord,
all those pleas regarding obtaining of information under the act, that was also placed for recall of that order. That was taken into consideration in the.
I may pardon, my lord. Before passing any order, lordship, may kindly go through my.
Definitely.
Only thing, my lord, this honorable court from time to time, if your lordship go through my note, this honorable court from time to time has directed that to complete the proceeding. And another aspect, my lord, only one aspect, my lord, I want to bring your lordship's notice. His allegation is that in connivance with accused number 1, I filed this case against the present petitioner. Accused number 1.
Whatever.
And he filed an application. This proceeding was filed in 2009. He filed another one CC in 2011 against accused number 1 and the petitioner.
These are not relevant.
No, my lord. What happened? He moved this honorable court that both the case should be tried together. That was rejected on the ground that he has already admitted his signature and the proceedings should be completed within 3 months. That was the order of this court in 2012. If you lordship, before passing any other lordship, kindly go through my note.
Okay. Yes, next.
This honorable court only granted me liberty to directed the landowner to give me reasonable opportunity, but that has been refused now.
Yes. Next.
I beg your pardon, your lordship.
99. Parties are there. 2 o'clock I'll take it.
The old lady is there before launch I answer.
90?
99.
90. Okay.
I beg your pardon, your lordship.
Okay. 99, huh?
My lord.
Yes.
The affected person and the informant, the mother of the affected person, both are present, my lord. And for the petitioners.
There are 3 petitioners.
My lord.
Have you implemented opposite party number 2?
Yes, my lord, on that day as well. On the order dated 16/1/2022, this honorable court directed me to issue take notice for informant. And that was not, cause title was not corrected. I have corrected in the last occasion.
Just see, Mr. Raghuram.
Santosh
Mahanti?
Other 2 persons, sir.
Santosh Mahanti, Jyotiranjan Mahanti.
The father of the boy who has got married to this girl who is missing was reported they were in custody. My lord had asked me to get them bailed out, and they have been bailed out. My lord, today after the girl, her husband have come to the court. The parents of the girl have
21, my lord, the IIC. Personal appearance case. IIC
Yes,
number
yes. 21.
Not a compromise matter, my lord. But the victim, in fact, my lord.
Where is the IIC?
You can take another. Item 2 is also possible.
You just call him. Item 2, I'll take it up. Password.
Item 2.
Yes.
Boss.
Call him. The moment he joins, I'll take it. Yes, 2.
May I please, Your Lordship?
Yes.
On last occasion, Your Lordship directed to the State Council to produce the entire record. His diary along with other document. His data entry item 2.
Right.
This is a case where a poor data
Have
entry.
you cured the defects? Whatever.
Well, I have already cured that defect because I have already filed that document.
Yes.
That in COVID period that this case has been filed.
What is this case?
This is a case, my lord. The present petitioner is the data entry operator, outsourcing employee.
Yes.
Initially, case was registered under section 420, 409, 34 of IPC against the Sarpanch along with others, my lord, including the present petitioner. They have suspected that the present petitioner might have played the role in the instant case. I have annexed the FIR, so also I have got that my lord certified copy of the FIR. In the FIR, it has been alleged under the MGNREGS program, my lord, this panchayat has to pay the labor fund through the online payment. That work has been entrusted by the punch. That is the usual practice, and this is the government order. Sarpanch is the sole authority. Thereafter, PEO, Panchayat Extension Officer, and Sarpanch, they have to.
What is the allegation against you?
Nothing, my lord. Nothing.
Nothing.
Your Lordship, I have annexed the FIR, Your Lord. They have might have suspected.
Who are you?
I am the one of the outsourcing data entry operator. Only they have to produce that document, I have to enter. And so also I have annexed that inquiry has been conducted. After that allegation, the inquiry report reveals that I am doing my job in a perfect manner. Performance of Satish Kumar Palo, ex-SCP, outsourcing.
Where is the stage of investigation?
The charge sheet has been submitted.
Cognizance, my lord, here.
Where is the charge?
Challenging cognizance, my lord.
Where is the charge? Cognizance has been taken, huh?
My lord.
What are the allegations against this man?
Charge sheet.
Your Lordship may can see the charge sheet. There is no allegation. I've got that. Your Lordship, I have one.
No, charge sheet is there.
Well,
Right, yes.
nothing. Whether any entrustment, Your Lordship, first of all, Your Lordship may can see the FIR.
FIR, forget about it.
FIR, there is allegation against the Sarpanch and the.
What is your name?
Satish Pal. Dakshineshwar, the Krishan Nayak is the main culprit who has done all these things. I am placing in this regard, it is seen from the statement of Sangeeta Behera, MG NREGS assistant, that she has handed over the above master role to Dakshineshwar Nayak, the GRS, Nuwakot Gram Panchayat, to who is Dakshineshwar Nayak, GRS stated that he had not received the above. Neither any entrustment.
This petition was arrested, my lord.
Yes, yes. That is the charge sheet. Whether any entrustment, whether I have created any document or manufactured anything, nothing else, my lord. Even though accepting for a moment, the Panchayat, Sarpanch and the PEO, they are liable, and the JE of the Panchayat, my lord. They have to verify it, they have to investigate into the matter and to produce the said document for approval. And approval, only my work is that I have to enter the said facts in the computer.
Where are the statements?
My lord. Statement there, my lord. But in fact, my lord, this petitioner was arrested in this case. This case, my lord. The forwarded report, my lord, they have filed the forwarded report, my lord. It is mentioned that during investigation came to light that the accused Krishan Nayak was working as a GRS and a Satish Pal, the pending petitioner, was working as a assistant computer programmer in Nuwakot GP under Papadhadi block. During the alleged period of the misappropriation, they intentionally with the region's intention prepare false labor list manually and converted it to the master roll
roll.
without any supervision of
Oh,
check
this,
by the
I understand.
colleagues
So
of my lord. That after my lord, another thing, the
You
witnesses
prepare,
also my lord,
you prepare
No,
the list of labor
not
working under the managram.
No, that is one of the forwarding report, your lordship. This is a case. Your lordship may kindly see the charge sheet. Brief facts of the
161 statement.
161 I have annexed. Your lordship may kindly see.
ସବୁ ସମସ୍ତ ସବୁ witness
ଟିକେ ଟିକେ 406 420 my lord. Where is the allegation?
Forget it.
49.
Where is the allegation that has been entrusted?
What is the name?
Satish Pal. Outsourcing employee, my lord.
Complaint statement my lord, page 28, last paragraph. ଜଣେ ପିୟୁ ଏବଂ
ସତୀଶ ପାଲ।
ସରପଞ୍ଚ ରିକ୍ରେଶ ନାୟକ ହେଲା ତା ତଳକୁ ରିପୋର୍ଟ କରୁଛି
ମିଛ ୟୁଜିପି ବ୍ୟାଙ୍କ
ସେମାନେ ଇଣ୍ଡିଆନ ପୋଷ୍ଟାଲ ଆକାଉଣ୍ଟ ନମ୍ବର ଦେଇଥିଲେ ଯେଉଁଥିରେ ମଷ୍ଟର ରୋଲରେ ଥିବା ଲେବର ମାନଙ୍କ ନାମ ନଥିଲା ପରେ MGRC ଟଙ୍କା ଗୁଡୁ 4 ଗୋଟି ଇଣ୍ଡିଆନ ପୋଷ୍ଟାଲ ବ୍ୟାଙ୍କ ଆକାଉଣ୍ଟ ଯାହାର ନମ୍ବର ରେ ଟ୍ରାନ୍ସଫର ହୋଇଥିଲା ସତୀଶ ପାଲ ଦି ପିଟିସନର ସତୀଶ ପାଲ ରିକ୍ରେଶନ ନାୟକ ମୋଟ 17,328 ଟଙ୍କାକୁ ସେଇ ଆକାଉଣ୍ଟ ଗୁଡିକୁ ବାହାର କରି ନେଇ ଯାଇଥିଲେ ଜଣେ କହିଲା ସମସ୍ତେ similar my lord Alex all
even though
one my lord another labor my lord
these are allegations. What else you need?
and Bisheswar Bishwai all of the my lord
taken the money, you have created the wrong list of
no my lord.
No will not make no because these are
Statement is there, my lord. Thereafter, the investigation has been settled to me, son. What is the facts and finding?
The police writes something. Police writes something while filing charge sheet will not conclude.
My lord.
They are not passing judgment.
My lord.
We have to see what are the evidence.
Allegation, evidence is there, my lord.
Evidence is there.
My lord.
What to do?
Then your lordship may can see a proceeding has been initiated on behalf of the prosecution, my lord. What is the facts finding? There is nothing against me. Rather, it has been.
You tell me how will you get out of this 161 statement?
My lord, to that extent, my lord, I am submitting before your lordship the entire record which has been the statement of the
you come to page what is this, page 28. 28 the statement of Ramakrishna Naik.
Ramakanta Naik.
Ramakanta Naik. He makes this allegation against you. Next you see the witness Alaka Uma Mahesh Jasti allegation against you. Thereafter you come to the statement of other witnesses. All the witnesses are saying that you are involved.
No, my lord, what involvement is there? They have stated that.
Ranjita Malik also.
Ranjita Malik also.
And Ardend Malik.
How will you get out of
my lord, I am coming. My friend is now.
Yes.
My lord. First of all, your lordship.
This is not a very big constitutional issue to be decided. Witnesses have said against you. Cognizance is taken. Go and argue if no charge is made out. No charge is made out.
No, my lord.
In cognizance says I can't do all this thing.
I am submitting before lordship. It's a case of 409. First basic point is that in order to suffice the 409.
Argue at this stage of charge.
No, my lord. Why, my lord? Hey, said outsourcing that type entry employee.
Maybe innocent, but allegation.
No, allegation. What allegation, my lord? 409. What is the enforcement? First of all, it is to be seen.
These are the things to be tested at the stage of framing of charges. Whether on the basis of
my lord, I am submitting before lordship. I will clarify because I have little knowledge of the charge and the cognizance are two different. Mere suspicions, a charge can be framed, my lord. A cognizance chapter, we have to see.
Is rightly taken according to me.
Because where is the case?
You keep on trying till 4:30 also, I will have the same thing. I am giving you option. You go and argue, move application, and say all these things.
Can I say before your lordship?
Yes.
To that extent, I will brought some decision judgment regarding the entrustment. But regarding the entrustment,
that would be a case where you can argue all these points before the court below at the time of framing of charges.
No, that's true, my lord.
Cognizance can't be quashed.
No, a person. Where is the allegation? What is the allegation?
All allegations. How many allegations I'll read? I'll tell you how many.
Each and every person they have stated that this is the facts. Facts. Where is the material, my lord?
Then 10 people have said against you.
How to that extent, my lord, they have to adduce that documentary evidence to that extent that I have committed any fraud, my lord.
Then you want me to conduct a trial here?
My lord.
Want me to conduct a trial?
No. For that reason, 482 along with 483 is there, my lord. Power, while your lordship is utilizing the power under section 482, simultaneously 483 power is there.
Kishore Benia also says so many witnesses.
Even what is the documented evidence?
Then comes preservation and create problem.
Thank you. It will not create problem for me,
Yes.
my lord.
Next, 21.
Front one, palace. Will personally appear before this court.
Yes.
In somewhere else, my lord, is not connecting.
He's not there.
He is there, my lord.
Let him come. Let him come. Whenever he'll come, he'll tell me. I'll take it up. Okay. Next, come.
23.
23. Pass over. We are not moving. today.
Milords. Matter, Milords, is covered by a lordship's judgment. It requires the
Yes.
income tax prosecution launched.
Yes.
And
Who was appearing for?
Lord, my learned friend, Mr. Mahanti, Senior Standing Counsel, he's appearing for the department.
Yes, sir.
And so far as Sri Metallics have, on the last occasion, I'd given Sri Metallics judgment.
What is
It is covered by the COVID-19. So it complied to 278 AA. There is reasonable ground. Because during the period of COVID was.
Lordship would see the max
delay about how much?
delay, my lord, at page 7, if your lordship would see,
Yes.
it ranges from 30 days, 5 days, 7 days, 1 day, and the maximum is March 2020.
You are covered by that circular also.
I'm covered by that circular, my
You
lord,
have
which
deposited the.
I've deposited the entire tax and interest. my
Allowed.
lords.
Lord, give. I'll write.
My lords, may I
Give that judgment also.
my lords,
One which I have.
Three metallics, and may I just pass on the other two judgments?
This last judgment which I
Last
have.
judgment is three metallics.
That is enough.
My lords.
And Mr. Mohanty is also conceding.
But he's always fair, my lords. And at least for COVID, he's very fair, my lords.
Allowed, huh?
Thank you, my lords.
They proceed.
Much obliged. my lords.
Record the appearance report. Whenever you are recording the appearance of senior counsel, you must record the briefing counsel. Everywhere you are writing only senior counsel. How can a senior counsel appear without a briefing counsel?
Mr. Saurav is there with me.
Naturally, the practice is only senior counsel name is written. Who has briefed? Nothing. You can't make a statement.
No, sir.
We record your statement.
Sir.
Tomorrow you will say that I don't know who has briefed me. So therefore, whenever senior counsel is there, briefing counsel name has to be there. Because he can't make statement on behalf of his clients and all. Yes.
Greatly obliged. my lords.
33.
Pass over.
Well, it's last person.
Huh?
Last person.
Yes. 33. Yes. Panjaya. What is the offense?
307 lordship, it's there.
Injuries, just show me the injury.
No injury.
No injury.
It's a false case lordship.
No, injury is there. Injury is there, but injury is simple.
Simple in nature.
Maybe. Why do you say no injury?
Lordship, what the client only told me, lordship.
Tell me the how many injuries are there? What? Who is injured? The same
The same person, one person is only.
One person.
Yes, Mr. Maharaj.
Yes.
Yes. Ask him.
Yes. But the injured name is Devasis Puhan.
He's the informant.
He's there.
He has sustained one injury on the left hand. That is simple in nature.
Madam, at the instance of opposite party number 2, FIR number 2 registered against the petitioner. The prosecution alleges.
Prabhat Kumar Mathur.
This is that from 29/10/2023 at about 11:30 p.m. 35 p.m. The informant went to Sai Temple at Rasulgarh. At that time, the petitioner in a drunken condition tried to overtake his car and abused him in filthy language and thereafter assaulted the petitioner. Therefore, the FIR was raised. When the medical report indicates that the opposite party number 2
Date each other.
one injury in his left hand, which is stated to be when the matters to investigation is on.
Investigation on.
When the investigation of the case was on, at that stage, the parties have settled their issues. And the petitioner has filed the present petition. The petitioner and the opposite party number 2 are present in the court, being represented by their respective counsel and identified with them. They have also filed the self-attested copies of their Aadhaar card to establish their identity, which are taken into account. The opposite party number 2 and opposite party number 2 has filed a yes, opposite party number 2 has filed an affidavit. Ms. Gayatri Patra entered appearance for opposite party number 2 and filed Wakalatnama, which is taken on record. The opposite party number 2 has also filed an affidavit dated 1/5/2024 inter alia stating that he has settled the dispute with the petitioner and he has no grievance left. Therefore, he has no objection to the FIR is quashed at this stage. Mr. Maharaja appeals for the state and submits that investigation is at a threshold. And although the in the FIR offense under section 307 has been registered, but the injury sustained by the opposite party number 2 is simple in nature. Since the investigation is still on at this stage, the petitioner and the opposite party number 2 have to settle the dispute. This court can give in as there is no legal impediment in the case. Taking into consideration the judgment of so subjecting the petitioner to trial even after completion of investigation for which offense will be a futile exercise. Therefore, this petition deserves merit apparently. Because how much you complainant has to pay to the victim, subject to the petitioner paying 5,000 rupees cost to the victim. Give 5,000 rupees to.
In the affidavit, he has stated he has not sustained any injuries.
5,000. Injury report.
Deeply obliged.
He will give 5,000 to.
Lordship.
Yes.
Obliged.
Yes.
37.
And give 5,000 rupees and place the report receipt here.
Lordship, item 37 pass over.
Pass over at this stage.
Lorded counsel, senior counsel is on legs.
Right on the at the request of our land council of petitioner, adjourned. Yes.
38.
Please, your lordship. The chair have challenged the entire proceeding.
37, your lordship, that may be disposed of because my lord, we have filed the application. He is for the opposite party. I am for the state, my lord. I have filed the application. 37.
Lordship, one pass over.
What is this?
My lord, that release of vehicle, the Sessions Court observed that the revision is not maintainable. And I have given the decisions of this honorable court that
Lordship, one pass
pendants of the confiscation proceeding, the release order has been passed by the London SDJ. So challenging that, we have prepared a application.
He is asking for pass over.
Pass over, Lordship, one pass over.
Let it be tomorrow.
Beg to pardon, my lord. Item 98, personal appearance of the petitioner and the victim.
They are there.
Yes, my lord.
93. 98. Today we are not able to move at all.
38 also the persons are present.
38 also.
No, the current.
Let us see 98 first.
Oh, okay.
98.
30. The questioning of entire criminal proceeding on the ground there that the petitioner and the victim, who is the opposite.
But he is in another duty that is unable to come with a proper dress.
Official meeting
Official duty also he will go in.
PS Rachi.
PSC.
So why can't he come?
I would PSC. I think the duty.
But even if he goes on official duty, you are supposed to be in the uniform.
Yes, that's true. But the situation not to adjustment, only to comply your lordship's order. That is why.
That's right. This is minimum. A officer appearing must appear in uniform.
Kaligas.
Keep it
Tomorrow. Yes. Yes.
Tell him to appear.
Yes, yes. Uniform. Yes.
Yes.
Please, your lordship, lord.
Yes.
Here I've challenged the order of cognizance. The fact that the matter has been amicably settled. The complainant is also present. my
What
lord.
is the offense?
Well, the offense is under section 498 304B.
Call them tomorrow, day after.
No, they are present, my lord. I am appearing.
Yes.
I am appearing today,
Okay,
my lord,
okay.
along with the affidavit, my lord.
Yes, yes. What is the settlement? They have part away.
No, here is a case 498A, 304 doubt death, 304B, 306, 406, 34 IPC, and 4 of the DP Act. Now, one application anticipatory bail is pending before the Honorable Court, and the viscera report was called for. This case is posted to 3/8/2023. So, part one of the petition is concerned. Manoj Kumar Swami.
23, sir, 24 is over there.
24 ହେଇଥିବ ଆଉ ମୁଁ କାହିଁକିନା ମୁଁ ସେଟା ଲିଖିଛି 3/8/2024 ଆଉ ଦୁଇଟା ଆପ୍ଲିକେସନ ଫାଇଲ ହେଇଥିଲା ଫାର୍ଷ୍ଟ ଆଉ ସେକେଣ୍ଡ ଅର୍ଡର ହେଇଛି that is also not
That is separate from.
Sadashiv Jena?
That is the complainant.
Father of the.
Yes, madam.
Father of the deceased.
What are the allegation, Mr. Maharaj? Just see.
But it is doubted, my lord.
Nature of allegation.
Nature of allegation, my lord. All the allegations is there. But more particular, my lord, this application is filed without giving any reference, without giving any certificate. That is the whole difficulty. Yes, my lord.
Nature of allegation.
Yes. Charge sheet has been filed, my lord. Charge sheet is page number 28.
What are the allegation against these people? Directly participated.
Statement तो किसी नहीं केवल चार्ज शीट टा जाचे हम सेटा देखियो
चार्ज शीट कौन लिखा है?
Lordship, may kindly have a glance to page 29.
29.
29, the medical report. That is at para number
29, huh?
12.
Yes.
12 lines from the top. The medical, the MO in his query report opined that the death of the deceased appears to be due to ingestion of paraquat poison, herbicidal poison, and its complications thereof. The death appears to be suicidal in nature.
306. Appears to be suicidal in nature.
That is the medical.
Taking all the reports. What is your name? Your absurding.
Petitioner number 1 is the husband.
What is his
And
name?
2, Manoj Kumar Swami.
Your absurding.
Yes.
It's my prayer for anticipatory bail. So far as was
Get
dismissed.
the statement, let us see. Get the statement.
Yes, madam.
If they've settled, if the informant is the father.
Yes, my lord. We have also.
He is not supporting the prosecution.
No, my lord.
In the trial, what will you get? Nothing.
Subject to correction, my lord, my friend is appearing. One application is pending before the Honorable Court. Whether that is pending or disposed of, that is better known, my friend. That application pending for consideration, that viscera report was called for by this Honorable Court by the coordinate bench.
As a bail application.
Bail application. So there कौन ଅଛି माने?
Bail application कौन?
I have to take it.
कौन standing order माने कौन? गोटे case रो adjudication ପାଇଁ pending ଅଛି. And compromise case file
That can be withdrawn, my lord.
You get the CD.
That can be withdrawn.
Get the CD. I'll just see. I'll see.
Without giving any certificate. No, certificate. You are bound to give certificate.
Okay, without going into all these things, you get the CD. Will see. Next.
Well, sir, I am only praying that until then, my lord, the matter may be stayed.
You are absconding. That's the whole difficulty.
It has. You file question.
And the allegation I want to see, you have not filed 161 statement.
No, you have not. Effect to a short date means without any interim order.
I'm giving it next week. You bring 161 statement and all, let us see. Here. 39. 39.
Your lordship may also record only that the informant is present.
The informant and accused, 38, right? The informant and accused are present in court today.
Accused petitioner number
1.
Petition number 1, present in court. Leave the matter from so Mr. Maharaja seeks time to get the PD of the case.
Yes, my lord. The
Yes,
petitioner
39.
challenging the cognizance order dated 5/3/2005, my lord, and the cognizance taken under section 341, 294, 323, 506, 379, 307 IPC, my lord. And during the course of investigation, the matter was amicably settled between the informant and the petitioner, my lord.
Yes.
And also one was granted bail at that time. So your lordship, the petitioner will be permitted to surrender and release on bail, my lord.
You settle the dispute, bring them.
My lord,
Huh? You say you have settled the dispute. 307. Cognizance causing is on the ground of settlement, you have to bring them.
your lordship may kindly permitted the petitioner to surrender and release and thereafter then will bring the
dispute will reject it.
ମୁଁ କାହିଁକି ବହୁ ଏକ୍ସରସାଇଜ କରି ଏମାନଙ୍କର ଡକୁମେଣ୍ଟ ସବୁ ବାହାରୁଛି ଏମାନେ ସାର୍ଟିଫିକେଟ ଦେବେନି ତାପରେ କୋର୍ଟ କହିବେ ଆମେ ସାର୍ଟିଫିକେଟ ଦବୁନୁ there is no bar so why should we go for the mental harassment?
This is unfair. You should tell the court that you have filed.
Everybody is saying that no, there is no bar.
But you can't be so adamant not to give declaration. On that ground also the court can dismiss the petition. You filed
At least consider that.
Have you filed anticipatory bail?
My lord, first or second or
Have you filed anticipatory bail?
Yes, my lord.
What happened to that?
Dismissed. The petitioner.
Is it not your responsibility to tell to the court that I had approached this court, anticipatory bail is rejected?
Exactly. My lord, I have mentioned the.
That is all. That is the fairness.
You should come to the court.
I mentioned the petition, my lord. Body of the petition, I have mentioned the same.
Huh? Where have you been? You have that order, rejection of anticipatory bail.
No, copy is not there, but he has directed to
Do you have the
surrender
copy?
within a period of 7 days and apply for bail. The same shall be considered on its own merit. That is the order passed.
The same thing I will have to do. The counsel for the petitioner seeks to withdraw the petition to
My lord, I pardon, my lord.
At this stage to avail his remedy under law at the appropriate stage. He submits that on instruction he submits that he would be surrendered before the court below on or before 30th of May 2024 and seek remedy available to him under law.
My lord, first or second order may kindly.
Any such application is moved or seeking the grant of bail, the same shall be taken by the court below on the same day. 40. At least you should tell all these things so that one can help. If you conceal these things, you won't get anything.
Yes.
Never do that. Yes.
Protection.
40. Vacation.
41.
Please, on behalf of Ms. Nanda, I may permit it. Here, my lords, I have challenged my rejection under 205 of the CRPC in a case under section 3 and 4 of the Explosive Substance Act. In a case registered under the Explosive Substance Act and under section 506 and 120B of the Indian Penal.
Why do you want exemption?
Well, I have prayed for 205 on the ground of my health condition as well as.
You are 44-year-old.
Well, I have been suffering from various ailments which I have annexed there too, my lords.
Show me.
That is annexure 4 series. Your lordship may see.
You are suffering from what?
Head drilling, weaknesses, and I have been prescribed for
What are the
medication.
diseases?
And so far as I am also.
You also may kindly turn to page 17. Page 17.
17, huh?
Yes. Para second. On perusal of the case.
What is this order?
You'll also be just
That's the order.
Yes. your lordship may kindly see.
Yes, on the perusal of the court.
That is your lordship's order. On perusal of the case record, it reveals that the accused is yet to appear in this case record and NBW has been pending against him. On perusal of the order of this honorable court, in CLMC number 742 of 2024, the honorable court has set aside the order dated 2010-2023, wherein the NBW was issued against the accused, subject to condition that he shall appear before this court on or before 20/4/2024.
I satisfied the NBW
Yes, my lord.
asking you to appear.
He did
Instead of
not
appearing,
appear.
you are
The
moving
time
to
put
05.
an application of 205.
Therefore, it is rejected. You appear, I'll extend the time. Appear and move press application.
My lords, with the fact that I may be given liberty in case of my appearance, my lords, parity may be considered also.
Agent, when you need exemption, you can move application. Who
Grateful.
stops you? Learned counsel for the petitioner, and in the present petition, petitioner is assailing the order dated. Order dated
Lords, it is 12/4/2024.
12/4/2024, passed by.
It is passed by the
JMFC,
learned JMFC Cog 1 Puri,
1 Puri in their case number
344 of 2022.
2022. 3/4 of 2022. Whereby the court below has rejected his applications under section 305 CRPC. It is relevant to note that earlier the petitioner had approached this court by filing, where is that, Satrana? By
Yes,
filing
that is at
CRLMC 742 of 2024, seeking quashing of NBW issued against him. This court, by the order dated 20th,
19/3.
20th, na?
Yes.
20th stage.
20th.
Stage set aside the NBW and granted the petitioner liberty to appear before the court on or before 20/4/2024 and avail remedy under law. So, instead of appearing before the court below, the petitioner moved an application under 205 CRPC, which has been rejected by the court below by the impugn order. At this stage, Mr. Pandal and counsel for the petitioner submits that his client would appear before the court on or before 30th May 2024 and avail the relief granted by this court while its order dated 20/2023 in CRLMC 742 of 2024. And he would be he further pays the liberty to move application under section 205 for personal appearance on his personal appearance on the ground of his ill health, and the same would be considered as and when such application is moved for exempting the petitioner from personal appearance on the particular date of hearing before the court.
Congratulations. May only the name of Miss Nanda may be reflected in state. I'll be misunderstood. Great.
42.
No.
42. Yes.
May I please, Your Lordship? I have come up against rejection of my prayer to be represented under section 205 of CRPC.
Yes.
Here a complaint case. Allegations are that we run an educational institution in Andhra. We created a branch at Berhampur. Then because of administrative problems, we handed over to the complainant and others. They are supposed to pay back. MOU was signed. They paid a part of it, then did not pay, for which the bank took over the institution. Civil suits were filed from both the sides. Instead, they filed a complaint case that was referred to police under section 167(2). Police investigated. That is the reason I have made the state a party in a complaint case, because they filed a final form.
Anyway, to 317 you move because all of you are in Andhra Pradesh. The case is
Well,
here.
205 is meant for that only, because we are in Andhra Pradesh. Every other day we cannot come.
Let us issue notice. Issue notice to the opposite party, written notice.
My lord, here it's very peculiar.
8 complainants are there. They belong to one family. 8 informants, it cannot. So at one family, so at least one, I think, will suffice. If your lordship says, I can take notice. They belong to one family, one address. Address is one, your lordship may see.
Yes, I can see that.
Yes. So 8 complainants will also something honored to.
9.
9, one is dead. So 8 is 8 third party. All are them complainants, not witnesses.
Share one of them, let us see. Share one of them, same address.
Same address. So
I will not write anything. You serve all of them. If one of them comes, then I will.
Then I have to take notice on all of them.
Naturally, because they are party, you have made them party. What to do?
I have to. But it's something unknown to law.
I know.
There cannot be multiple informants, multiple complainants.
Notice niyanto.
Okay, notice.
And let them produce the document. That will indicate a final form. It's a civil dispute,
No,
violation of
this is
MOU.
156(3).
That was referred to. Police filed a final form. This is a protest petition again.
ଆଉ ତ ସେଥିରେ କଣ ଦରକାର છે ଏଥିରେ ପ୍ରୋଟେଷ୍ଟ ପିଟିସନ ଯଦି ପ୍ରାଇମା ଫେସି କେସ୍ ହେଲା ହେଲା
What is the amount involved?
Amount Millers, they have defaulted. 1.5 crores they paid. Rest, they are supposed to clear the whole dues and run the institution. Institution was handed over to them. They ran it. They paid the initial 1.5 crores. Then they defaulted in rest of the payment. Bank took over the property and we are ruined in the process.
Have you attempted to settle the dispute outside court?
No, they never wanted to, Millers, because civil court, both the sides suits are pending.
Therefore, you go and explore the possibility of settlement before the.
I have to take instruction, Miller.
District court forum.
I have to take it. Because.
That's better idea. There are suit pending and so many, these are business transactions. You can settle the dispute. You are also a businessman. Why should you waste time in litigation?
No, that business is lost. Now, I have mentioned, we have individually, one is working 2 persons, third is an institution. So one is working as a principal in a college near Andhra Pradesh, near Vizag. Another has in.
Okay, you explore the possibility of settlement. I'm issuing notice. I'm staying the proceeding and go and participate. Right on. Issue notice to the opposite parties. Mr. Maharaja accept notice for opposite party number.
No, he is not required.
9.
Copy has been served.
9. Okay, 9. Opposite party number 9. You have implemented.
No, implemented for the record.
Petitioner is agreed by petitioner is agreed by the order dated.
Final form.
Order dated 27/2/2024, whereby his application under section 205 CRPC has been rejected by the court below. Full stop. Issue notice opposite parties also. Since the dispute appears to be a commercial dispute between the petitioner and the complainants, it would be appropriate that they should explore a possibility of settlement before the mediation cell, district mediation cell. Accordingly, the parties are relegated to district mediation cell Barampur. Barampur. The coordinator of the mediation cell is directed to issue notice to the complainant and the present petitioner by fixing a date of hearing and a date of hearing, awaiting the mediation report. These the matters also in the international, the proceeding in the further proceeding in IC case number 274 of 2019 is stayed. And once explore, it will come over. You can settle.
This decade, dispute is.
Let us see explore.
2014 is the MOU.
43.
May I be the lordship? Madam, actually order dated 24/2/24, and whereby the learned trial court issued proclamation in favor of me, my lord. The victim as well as the informant who expired in the meantime on 1/6/23. That about the co-accused already released on bail. Present petitioner is the laborer due to he has not appeared before the learned trial court. That is why the proclamation has been issued.
the offense under section 363, 376, 506, 368, 34.
76 is there, everything is there.
Page 27.
Page 27.
Yeah.
Annex 5.
Boxo is there. What to do?
Co-accused released on bail.
That's right.
The victim, the informant already expired, my lord. 1/6/23.
Yes, Mr. Maharaj.
Victim informant died कर आप केस के किसी ने तो जहाँ तो ट्रायल फेस करना
I'll set aside the proclamation order.
Yes, sir.
Until it
Yes.
is read out.
Yes.
Petitioner is agreed by the proclamation order dated
Oh, right.
24/2/2024. Let counsel for the petitioner submits that the informant
and the victim
both of informant and victim in the case have already expired. Already expired. The petition, since the petitioner was absconding, the proclamation order has been issued against him.
Yes.
On instruction, he submits that his client would appear before the court on or before 30th of May, and seek appropriate remedy under law, subject to petitioner appearing and moving appropriate application in accordance with law. The proclamation order dated Chobisi to 2024 is arrested.
Yes.
Yes.
Allowed. 44.
The petitioner here challenges the order dated 21st February 2024, rejecting the time petition filed by the present petitioner to adduce defense evidence. Defense evidence. The Lordship shall kindly see Annexure 1, that is the petitioner is a government teacher. He was to attend on the date fixing the date, that is Annexure 1, page 8. That the training program was there on 21st February to 22nd February 2044. The region किसी दिया ही नहीं, page 12 and page. Lordship may kindly see page 12. No region has been assigned. Yes, I have annexed the petition. Annexure 2, page 11. Your Lordship may kindly see. The accused person is a government teacher. No, eight किसी region नहीं. Without any assigned any region is rejected. London Trial Court.
You manufacture all regions here.
किसी नहीं खाली reject. पर reject कौन है? कहीं की reject है ला सेटा उड़ा किसी दबा को था region. No region.
What is the offense?
My lord, offense 138 of NI Act. Notice जाओ तुम बाबू.
Notice करो.
Notice जाओ. Complaint case जाए तो stay out further proceeding.
This side of the vacation, I'll dispose it. I'll give one opportunity to you to lead defense evidence.
Lordship may dispose it by setting aside.
A complaint case without expanding. So therefore, you serve this side of the vacation. I'm keeping it. I'll allow it.
Your Lordship may kindly stay till that.
No.
But because your Lordship may kindly see the case is posted for argument and twice they have taken time. That's why the argument may fix it. Defense closed कर देसिन. Defense is closed. Time is rejected. Defense is closed. That's the
for argument.
Yes. यार कोरिया को था नो. जल्दी भी कर चुके किसी भी region दबा कर.
ଆପଣ ବି ତ reason ଦେଇନାହାନ୍ତି.
No, ଦେଇଛି ନା. More written Annexure 2, your Lordship may kindly see. The accused person is a government teacher at Kanpur UP school and due to his engagement in training at Nimapada, he is unable to adduce his evidence today. That is on 21st. And training program is there.
The petitioner being the accused in the case under section 130 NIA moved an application dated
For adjournment, dated 21st.
21st February 2024 inter alia seeking for adjournment of the complaint on the ground that he
To adduce evidence, defense evidence.
The petitioner petitioner stated in the application that he being a government school teacher is engaged in the training program. Therefore, we sought further time to lead defense evidence. The learned court below, by the order dated 21/2/2024, has rejected the application without assigning any reason whatsoever. Issue notice to the opposite side, returnable this side of the application, and in the meantime, the proceeding in the ICC case number 2614 of 2022 pending before JMFC mentioned state till next date of hearing only.
Lord S. Mishra, JMFC Bhubaneswar.
Don't write meaning.
Much obliged. Also.
Estimate হচ্ছে না কিন্তু
Specific date ওটা করে দিন।
only one company. 71. 71. Both are present. And 9/12/2023, their record has been still recorded by.
71. 71.
Lordship may see that 9/12/2023 order. That is there on the. Yes. And the affair, Lordship may see. वो घरू बाहर कर देइछन्ती प्रतिशत देइतले बाहवा पई I'm suspending this sentence. Yes.
Obliged.
My name may kindly be reflected on the top of the brief as well as in the court which stands for.
Mr. Sanjay Das name to reflect in all the cases, huh? All the cases.
Free copy of the order.
Yes, free of cost.
Obliged.
46.
46 my lord, DA case 13(1) each and punishment 3 years and fine.
3 years and
Fine my lord.
appeal admitted, sentence suspended. Are you in custody?
No my lord.
Suspended. Okay. Yes.
47.
May I lord, please the lordship my lord.
Yes. Mr.
The
Das
appellant-
appearance also. Huh? Yes. Yes.
The imprisonment for 3 years under section 13(2) and 13(1)(c)(d) of prevention of
Are you in custody?
my lord. And in the
Are you in custody?
my lord.
Yes,
And
my lord, for 4 years under section 409, my lord.
In this
You are in custody since?
Is the date of judgment, my lord.
20, no my lord, 28/23 my lord. 28/23/8/23 my lord.
Appeal
And
admitted. Appeal admitted.
in this case
Sentence suspended. Next petitioner is in custody since
23/8/23 my lord.
23/8/2023. Huh? Review of the impact of the appeal is admitted and hearing of appeal is
I may be pardoned to mention something, my lord. The petitioner is involved in a series of cases, my lord, more than 7 cases. In this case, judgment was pronounced on 21/3/2024. He has been remanded in other 7 cases, my lord. So from the date of judgment, he is in custody in this case, my lord. And the co-appellant has already, my lord,
My lord.
from the date of judgment. Where is the
My
judgment? Yes. Petitioner is in custody. Since
21/3/2024.
21/3/24.
ठीक है? Granted way. To the
Okay.
satisfaction of the court. Yes, granted way.
My lord, another co-appellant has already filed CRLA 304 of 24. 304 of 24. It has been admitted since 9/4/24.
Yes. Tag
So
with that.
this matter may kindly be tagged with that
Number,
yeah.
you give the number.
304 of 24.
24.
Tag this.
CRL.
Yes.
And free copy be given, my lord. Obliged, my lord.
Next.
You lost 2 years.
47.
48.
Lordship.
48.
You lost 2 years conviction, Lordship, 10,000 fine, Lordship, in PCR, Lordship.
Are you in custody?
No.
No. Admitted, sentence suspended. Yes.
49.
Beg to submit, my lord.
Yes.
I file a petition to exhibit the government records, my lord. That is the video work order. That was rejected by the vigilance judge, special judge, Baleshwar, my lord.
Sorry, I didn't follow it.
3 cases, 3 documents admitted, 3 work order. Total 43 work records are there. Vigilance case started against that. That he has taken bribe, put signature here. All records comes before the court. 3 records exhibited. Another 40 records are there. It is simple to be because it is a work order of the video. Video that was rejected. I annexed the nothing. It is automatic government record to be executed. And my lord, I filed the 43 acres, sir. Such a case, my lord, a peculiar case there. I was before my lordship. Ah. The honorable before the honorable High Court, my lord. High Court directed lower court to call for all the records.
Sir, I am not able to follow you anything. What exactly you want? What was your application?
My application was there, was for my lordship, that 43 Indira Awas work, Jodhana work orders was there with video.
Okay.
Of Jaleshwar. And that was called for as for the order of the Honorable High Court, my lord.
Yes.
Before the lower court, because it is a vigilance case, and that case was registered, taken bribes, and thereafter put signature in the MB book, thereafter payment of that is the allegation. But it is seen, nothing is there. All payment has been taken by the informer.
Prosecution wanted to rely upon those things. You are the accused.
Relied, FIR is like so. Lingering case.
You are the accused.
Yes, my lord.
If the prosecution is not willing to rely upon certain document, how
No,
does
that
it
is that
prejudice?
is the allegation.
That you can lead that in your defense evidence.
My lord, what happened? Already exhibited that document.
Then what do you want?
3 records are exhibited. 43 records are there.
Good.
That is with the court.
If the prosecution is not bringing some record,
No, that is
which will
earlier
go in your
order.
favor.
No, that is earlier order of the Honorable High Court to produce before the court will.
If even then they are not doing, how does it make difference to you?
That through
How
court.
it is prejudice to you?
My lord, that is.
The prosecution case will be damaged.
No, that is not, they are lingering for a bind, twist for it. That is lingering, nothing passing for them, my God. They have already taken the payment. No case should be registered. That's why they are not.
What is this? You are forcing the prosecution to bring
Yes, my lord, that
evidence
is-
against you.
In Pichi Act, my lord, if a false case is given, then he right with the defense to take it.
Show me which paragraph you are agreed of.
My
The
lord.
impugn order.
My lord.
You have challenged the order dated 19/1/2024.
No, my.
That's your prayer. That is what you have filed in the petition. You have made that prayer. Set aside the order dated 19/1/2024.
That is the order, my lord, that order is the page 8, my lord. Page 8.
Now, which part of the order you are agreed of?
From the record is found now, evidence on the side of the prosecution is continuing. The 40 numbers of IAY, that is Indira Awas Yojana.
Where are you reading?
Page 12, man. Impugn order.
Yes.
Para number 6. From the case record, it is found. Now, evidence on the side of the prosecution is continuing. 40 numbers of Indira Awas Yojana, IAY. Case records which were sought for to be exhibited on the side of the defense, because I have taken earlier order.
Yes, read it.
Are not seized by the IO for the prosecution case as submitted by the learned
Assistant AP.
The prosecution has not been admitting those 40 numbers of IA case records to take into evidence on the side of the defense. So it appears those 40 numbers of case records can be taken into evidence and mark exhibit on the side of the defense on confrontation of the same to the PW during their cross-examination by the defense as per the order of the Honorable High Court. High Court ordered it.
Yes.
What is that? Or through examination of each witness during the defense evidence subject to cross-examination by the.
What is wrong in it?
What happens, my lord? Only that is there with the court. And out of 43.
The court says that you can confront with the witnesses or you lead that in a defense evidence. What is wrong in it? That is a different story. You are agreed by this order, there is no legal information. The court only says these are documents are there. If you have to confront those documents with the prosecution evidence. Prosecution evidence is going on.
To whom I will, whether the video
I don't know.
That is.
You ask your
They are
lawyer.
not- They are not a prosecutor.
You ask your lawyer who is representing you in trial court. I can't advise.
I am conducting. I am conducting.
Then you take the call.
Number of time from.
With whom which document has to be confronted.
My lord, for that
If,
is.
if anything is left, you lead the definitive evidence. That's what the court says. What is wrong in it? There is nothing wrong.
My lord, I may be permitted to submit before my lordship. Any of the witnesses are coming through prosecution, I can confront it. That order may be.
That's right. That is what the high
That
trial court is also saying.
No, he is not giving. They will work because the prosecution is not supporting. Na? The prosecution is not supporting my content.
Why should prosecution will support you?
That is
Prosecution will support prosecution.
That is the allegation.
Maybe prosecution will support.
No, that is the allegation.
Prosecution will not support you.
FR may not be seen.
Right on.
FR is
Okay,
there.
it's all right. I'll record.
My lord may give liberty
Right down.
to cause.
Petitioner is agreed by the order dated one. What is that number? 19/1/2024.
Files in TR case number 114/06.
Whereby the application moved by the petitioner is rejected by the special judge vigilance. Vigilance. The petitioner, the counsel for the petitioner contended that he may be allowed to confront the prosecution witnesses with the documents. The documents which are part of record, and in the event he is not able to confront, he may be allowed to lead defense evidence. The court below has precisely given that liberty to the petitioner by this impugn order. Para 6 of the impugn order is relevant. Page 12, para 6. In view of the aforementioned observation made by the trial court while rejecting the application of the petitioner, no further order is required. No further is required, and the petitioner the prayer of the petitioner is covered by the impugn order. Hence, no interpretation.
Needless to say. Needless to say.
Needless to say that the prayer of the petitioner is covered by the direction of the trial court contained in para 6. So no interference is called for. I have given that liberty. You can confront or you can lead. I have given that liberty. I have given that. Yes.
And in fact, that particular orders, Lordship quoted that once.
I am quoting that.
That suffices. That suffices.
That's what I've said.
No, that is that no. You are going somewhere.
That lane supports to your case, sir.
It will support you, sir. You.
My lord, 20 years of the case is pushing.
That's a different issue.
No, the case is not there.
20 years. Yes. Dispose up.
Lordship may record my presence.
Record.
Sangram Das, standing counsel.
Record.
Standing counsel figures.
Yes.
Item 50, there is a delay of 46 days in preparing the revision.
When in fact, in both the matters, my learned friend appears on his behalf, I'm submitting, my lord, both the revisions directed against orders, where the rejection of the 50-51 lords. Both the magistrates for orders for in matter of condonation of delay, lords. In fact, revisions directed against the orders rejecting the discharge application, and the delay the register has indicated against rejecting the discharge application.
Okay.
But in the meantime, my lord, charge has been the charge has been framed. Anyway, my lord, today is for condonation of delay. 46 delay has been indicated by the registry. My lord, you allowed it. My formal objection will be recorded.
There is a delay in both the cases.
Yes. Both the cases 46 days. I verified.
50-51. The petitioner has moved IA number 242 of 2024, seeking condonation of delay of how many days?
46
days. Mr. Das opposes the condonation of delay, but object the application. However, taking into consideration the contention raised by the petitioner in the application, the delay of 46 days is condoned.
Same thing in the second
review, 43. Delay condoned. Yes. Merit will decide.
Next issue.
merit you just see issue notice on the main petition.
Yes.
Both the-
52.
52, 52, the lordship challenging the order dated 7/51/24. Here the present petition is the younger brother of the accused vigilance case, one has been trapped. And his account to 3,50,000 has been seized, which has been got from the selling his property. That was in his account. That has been seized. Now the vigilance authority has said that we have not seized anything. Your lordship can see the order. Legal list I have given.
Your lordship permits, my lord, lordship turn to page 66, my lord. 2 lines of the input orders, my lords. It says that when the amount as asserted with petitioner is not part of the present case record, so this case 7 of 2023, keeping in mind the provisions for, my lord, that's he says that for 457, my lords, for a release of the seized amount of 3,50,000. Now the prosecution says that no report about seizure of the free bank accounts of the petitioner.
Turn to page
Anyway,
60.
my lords, at the, my lords,
Whether it is seized or not, that's the question.
62, your lordship can see the seizure list I have annexed.
no, may suggest one thing, my lord. This case coming for the first time, my lords. Is coming for the first time. This case, another case is 55. In both the cases are same, arising out of the same GRS case 723.
Have a glance.
Lordship, take it.
Whether it is seized or not, that's
Yes,
the
but
question.
No, no,
it is seized,
input
seizure list I have given.
one minute. One input order indicates I have not received. I may expect
Let the
this
wrong order
by
has been filed.
tomorrow.
Next week.
Next week.
55 and this one.
52 and 55.
5 years.
Arising out of the same TR case number 7 and 2.
Wife.
Notice, each notice.
The input order indicates that there is no seizure, but I will get the instruction.
Mr.
I have
Das,
annexed the seizure list, my lord. Page 62, I have annexed the seizure list.
Take it, I will take it.
if it is there in seizure list, he will say, yes, it is there, he will cut sack. Simple. Yes.
53.
53.
Your lordship fixed both the cases to next week.
I plead your lordship. The petitioner and another, your lordship, they have been convicted for 7 years and to pay a fine of rupees 50,000 in default to undergo RI for 6 months, your lordship. 2 accused persons will be convicted and that has been confirmed in the appeal, your lordship. This is the present revision, your lordship. And one of the co-accused has already been, his case has been admitted and already entered on bail by this honorable court, your lordship.
Undergone? How much?
Never have.
Undergone.
Appeal disposal for a revision file.
7 years.
7 years conviction, 50,000
Within
fine.
3 years,
Your lordship, two person has been convicted. One has already been his case.
How much you have undergone? Tell me at least.
13 years.
See, presumption of innocence is no more available to you. 2 courts have convicted you. 2 courts have convicted you.
Yes, sir.
The
2 courts convicted 2 persons, your lordship.
That's right, but that will be a parity ground. But the presumption of innocence has gone.
That
So therefore, you tell me how much you have undergone. Accordingly, we will grant bail. Tell me how undergone.
that information I don't know.
Okay, they have come on. You get the information under. He is also accused.
Yes, your lordship. Same case, your lordship.
You see, then how will you differentiate?
What happened, my lord? Copy is not with me.
Lordship,
Show me the accused. List, no.
yes, your lordship, annexure 1.
Appellate court.
Page 14, your lordship.
14.
Page 14.
This is the appellate court order. Huh?
No, that is the trial court order.
Appellate court, trial court is Lalit and
Yes.
Praveen Ranjan.
Praveen Lalit Sabha, the present petition.
Sentence same.
Sentence same, your lordship.
Same.
Yes, your lordship.
Appellate court.
Appellate court, page 66, your lordship. Annexure 2.
Where is Praveen Ranjan? And only Lalit. Where is Praveen Ranjan? Praveen Ranjan has not filed.
There are 2 different appeal, your lordship.
Where is that appeal? Who's his appeal?
His appeal-
Separately disposed of.
Yes, your lordship. Both the persons filed different appeal.
Maybe his sentence might have been reduced. His sentence might have been reduced. Be sure about what you are saying. What is the sentence awarded to both of them?
Let it come day after tomorrow.
You
Let it
don't
be,
know-
let
you
it be,
don't know facts. He also will go.
let it be listed along with this, your lordship.
No, that appeal is admitted here.
Yes, your
Revision.
lordship. Yes, your lordship.
This revision along with that. ठीक है
ସେଇଥିରେ ଅଛି।
Just see, only Lalit has filed the appeal. What happened to
Revision number 110 of 20.
Pravir Ranjan? Just check it up. Yes.
54. May I please, Your Lordship? Petitioner has filed a petition for discharge from the charges, and the same has been rejected by the annexure 5 minor order dated 17/2/2024, passed by the Special Judge Vigilance Balasar, my lord, at page 99.
But, this case is taken off the first time, my lord. Your lordship, turn to page 106. 106, that the operating portion of the input orders, my lord. There it indicates that 6th March was the date for framing of charge. Now, prayer made in this revision application.
No, charge has
the
not
broader,
been
eh?
Charge has not been framed.
That instruction I will get. If the charge has been applied, that prayer has to be amended.
Issue notice. Mr. Das, accept notice. Yes, next.
56.
You tell me.
My lord, on behalf of Mr. Joydeep
You
Pal,
tell me when you got the bail.
neg- on 20,
People have no.
my lord, the council is absent, so on behalf of Joydeep Pal, kindly urgent the matter.
Petitioner of the bail due to his absence. NBW was issued by the court of JMFT Niali on 15/12/2022 in DR case number 817 of 2015. On instruction 37. Yes.
57.
Dispose of.
May I please proceed?
What about the other matter? There are two matters.
সেটা স্টে ଅଛି সেটা স্টে ଅଛି কনফিডেন্স କୁ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି ସେଇ କେସ୍ ତା ସ୍ଟେ ଅଛି ଆମେ ଆଗୁଆ in respect of other actions.
Already.
57.
May I please, lordship? Lordship, meantime, charge sheet has been submitted showing the petitioners as absconding, and accordingly, envelope has been issued. Yes,
Charge sheet been filed showing the petitioner as an
lordship, I may pay one thing, my lordship.
Sorry.
Lordship, in the meantime, the principal accused, it is the case of custodial death. The principal accused, who is the station head, already appeared and released on bail by the law notified lordship and directing first of second of verity.
And petitioner was shown, petitioner is an accused in FIR number shown to so. After investigation, charge sheet has been filed on 11/2/2023, showing the petitioner is an absconder. On the request of IO, the NBW has been issued against the petitioner on 16/2/2023, 16/2/2023. On instruction, petitioner possible the petitioner subject that the appeal report has been so and the remedy also the petitioner further submits that the principal accused in this case has already been enlarged in bail. Therefore, he would move an application for bail seeking parity with the principal. If such application is moved, same shall be considered on its own bench.
Same day on the lordship observe
On
one.
the same.
Lordship observe one line, lordship take into consideration the evidence are reduced in respect of other
Do you
two.
think that the application will be considered without looking into the
Lordship,
record?
in the meantime, let's see the other co-accused.
Don't denigrate the
Lordship.
court below.
There are two
They also read it and pass there.
There are two petitions, lordship.
Which one?
No, there are two petitions, lordship, dictated like the one petition. In fact, there is two.
Item number?
Item 57, there are two petitions, lordship.
57. 44571.
Lordship.
Another is 847.
No, no, see that lordship wrong. The lordship dictated like one petitioner. In fact, there is two petitioners. Lordship.
Petitioners.
Petitioners.
Yes.
Outline.
58.
Lordship courts below lordship on the same day. Can I go to like
Courts
courts below?
below, I have said.
First half, second half. This was the same day by the court.
This jurisdiction I don't understand. First half, second half, third half, I don't know.
Lordship.
If the second half the judge is not there, he will go to his house or what? What is this first half, second half? I don't know this expression. New jurisdiction is created. First half jurisdiction, second half jurisdiction. What is it?
No, first half
What is the meaning of it? You tell me.
on the first.
Suppose second half the judge is not there. What will happen?
In fact, while surrendering, we are taking the
Don't say all these things.
availability of the.
I have said this much same day. That is enough. Don't say first half, second half.
Courts below lordship.
How do you define first half, second half?
On the par.
If the morning court is there, then
No, both the previous.
suppose morning court 7 o'clock.
Then
What is the
the
second half?
sessions were also on the morning hour, lordship. Sessions were also in the morning hour.
Second half, first half.
Lordship.
58 years.
To main period. Petitioner order at 49/20/22.
Yes.
The order
On bail, you are on bail.
No offense. No, one thing. Offense under section 363, 366 IPC and 12 POSCO Act.
Charge sheet was filed. Charge sheet was filed.
363 IPC.
1 minute. Charge sheet was filed against the petitioner, showing him with an absconder. Absconder on the request of the IO, NPW has been issued by the court below on 14/9/2022. 22. On instruction, petitioner submits that he would be appearing before court on 30th of May. So, and seek remedy available under
In the meantime, the main accused is already released on bail. The same day disposal.
The petitioner submits that the principal accused in the present case has already been granted bail, so therefore he will move application for grant of bail on the ground of penalty. If such application is moved, same shall be considered on.
Obliged.
59.
MBW 8/2/2024 absconder.
Huh?
Absconder MBW.
Yes. By phone.
Lordship, in the CBI matter, my presence may be recorded.
Yes. I'm cancelling it. Okay. NBW.
Yes,
Okay.
Lordship.
The petitioner, the charge sheet was filed. Do you have the date?
Yes, sir.
The petitioner is accused in FIR number so and so.
Charge sheet filed on 31st/12/2010.
Charge sheet was filed on 31st of June 2010, showing the petitioner is an absconder on the request of the
And
IO of the case. NBW was issued on
8/2/2024.
8/2/2024. Petitioner is agreed by the state government.
Actually, this is CBI matter.
It is Mr.
Saptak is there.
Mr. Nagin appealing for this.
May record my objection.
You are very present to indicate that you are objecting. Right.
Petitioner counsel, but petition is absent.
None appear. Why to write on?
Yes.
Very good. Subject to petition appearing. Subject to petition appearing on 30th May. Okay. Okay. Next.
60.
Your Lordship, in that yesterday's matter, my argument may be recorded, Your Lordships. That
Yes, I have recorded everything. That paragraph also I have reproduced. Para 16.
Yes, Your Lordships.
Yeah.
Yes, Your Lordships.
60.
60.
60
Yes.
NBW 24/4/2023.
Yes.
Belgium.
No. He was on bail.
Yes. No steps taken on his behalf.
So many people are there. No, how many? Petitioner was on bail, but due to his absence in the court, the NW was issued at 24/2023. What? Okay, so 500. Same order. Okay. Yes.
61.
मैं pardon. Yes. Completely healing. Non-apparent side. No. Appearance. Do you have the date of when you got the bail? Item 59, 60.
60.
63. Give the date. 61 कौन देखो तो 61
Order dated 1/8/2019.
1/8/2019. Yes.
My lord, petitioner was enlarged on bail on 27/4/2019.
Yes.
Thereafter, my lord, NBW issued on 14/3/2022.
Yes. 500 pension. Yes.
62. नहीं से condition टा comply करना है तो warranty इसी condition टा अपन reflect
Oh, they'll apply, move application and do whatever. Yes.
62.
May I please your lordship? 43/12/2021 is the NBW issue. NBW issue. The glance at annexure 4. In the meantime, the men accused the husband and the mother-in-law.
When you were on bail, no.
No.
Next
Okay.
day, you have absconder anticipatory bill first or second are not compliant. I have paid for issuance of NBW issued on 23/12/2021. He's abscond.
Petitioner.
In the meantime, my lord, kindly glance at the
Charge
annexure
sheet.
4.
Petitioner is an accused in a FIR number so and so. Charge sheet in the present case has been filed on 25/12/2021, showing the petitioner is an absconder. He applied for anticipatory bail before this court, which was rejected.
Yeah, first or second or
He applied for anticipatory bail before this court, and this court has directed the petitioner to appear before the court and seek remedy under law. If such application is moved, the same was directed to be considered on the same day. However, the petitioner did not comply with the same order, and eventually NBW has been issued against him by order dated
23/12/2021.
Petitioner is agreed by the same order. Proper court undertakes to appear.
My lord, annexure 4 is the main accused has been already been acquitted, my lord. The main accused, the husband and the mother-in-law.
Land Council
He is the-
petitioners further submit that the principal accused in the incident case have faced the trial, and the court of sessions special judge, sessions judge special judge Kendrapada, while its judgment dated 23/12/2023 in ST case number 17 of 2022 have been acquitted the accused persons. He admits that he would move application for bail on the ground of parity, and on the ground that the co-accused persons have already been acquitted in this case. He may do so by moving such application if such application is moved since application on action merits. Yes. 63.
May I please proceed? Well, prior charge sheet, the NBW order issued by the Lord and Court below, as per period of the IO. In the meantime, charge sheet has been submitted. 17 witnesses examined. Out of six, 5 accused persons already released on bail.
This is the 5th time, my lord, before your lordship, and no certificate has been given. NBW issued on the prayer of absconder.
5th time he came to this court.
This court and no certificate. This is the 5th time.
Anticipatory bail asking.
Whatever, you will not disclose those things. Right. The petitioner is an abscond, and the petitioner is an accused in the FIR number so and so. Charge sheet in the present case is filed on 31/8/2021, showing the petitioner is an accused, is an abscond. Petitioner had approached this court as many as 5 times. Four
times
for with the prayer to pre-arrest bail, which has been rejected. Unfortunately, in the present petition, no such declaration as required under the procedure has been made. Be that as it may, the trial court by the order dated
31/8/2021
has issued NBW against the petitioner
on the prayer of IO.
On the prayer of the IO of the case. Petitioner would appear on so and so. The NBW issued by the court of JMFC Odagaon in
In Saranpur PS case number 60 of 2021.
in
PR case number 99.
SC case number, in the SC case number 23 of 94, isn't it?
Of 2021.
23 of 94 is
Yes.
shall remain kept in abeyance. Execution shall remain kept in abeyance, subject to petition surrendering before the court on order before so and paying cost of 2,000 rupees to the bar association. 2,000 rupees.
Clarity maybe. Okay.
64.
May I please? Page 6, your lordship can. On 41 CRPC, he was there during peak COVID period, non-appearance, page 6. It is 24/11/2020.
Petitioner is an accused. Petitioner is an accused in FIR number so and so. During the investigation, 41 a notice was given to him, and charge sheet was filed subsequently, showing not arrest or absconded.
Not arrested.
Not arrested. Arrested. Eventually, the trial court, by the order dated 24/11/2021, issued NBW against the petitioner. And when constituted petitioner submits that his client would appear before the court on and so and so, and so on. Subject to petitioner appearing before the court as stated above, the NBW issued by the Court of Sessions Judge cum Special Judge Niagara NTR case number 82 of 2017 on 24/11/2021 is surrender. Subject to petitioner paying cost of 500. Yes. उसके बाद क्या है? Bail. 65 देखो 65 65 this after this matter. Yes.
Your Lordship, we are seeking for a cancellation of bail on the ground of suppression of earlier bail applications before this honorable court, Your Lordship.
You know, just before one matter, what had happened? The lawyers are not disclosing how the clients will be responsible. That may not be a ground for cancellation of bail.
Your
It
Lordship,
is a liberty granted by some court.
Your Lordship, that would not be a ground for cancellation of bail if it is not a material fact or it would not influence the mind of the learned judicial magistrate, Your Lordship. But the circumstances in which the bail was withdrawn from this honorable court, the same was suppressed and a bail was taken from the court below, Your Lordship. That is why we are seeking for a CRN. And we do have precedents where bail has been cancelled on that very ground, Your Lordship.
Who is appearing for opposite party?
Your Lordship.
Yes.
The
The problem is you have withdrawn the no, it was pending before this court.
Was pending before.
And you have not disclosed it.
No, that's not a fact. My lords, look at page 27.
27. Yes. Yes.
The order is dated 16/11/2023.
Right.
And bail has been allowed on 16/11/2023.
Yes.
My lords, matter was in the list on that day in this honorable court. In the first hour, mention was made that I may be permitted to withdraw the application. This bail was moved at 2 o'clock, my lords, with a certificate.
Where is your application? Where have you said that the petition is pending before High Court? Show me your bail application.
Pending.
If you have concealed this fact from the court, then it is a very serious issue.
My lords, a memo has been filed that nothing is
So
pending.
this is I tell you, this is the mischief. Show me the application, bail application.
If the matter.
Where have you said that my petition is pending, my bail application is
Your
pending
lordship,
before
look at what I have stated in the counter. I have filed a counter affidavit, your lordship may kindly.
Like, show me the application. I don't need pleadings in this case. Only I will see the application. The application, whether you have disclosed that my bail application is pending before High Court.
The application.
Okay.
Show me the application. If you have not disclosed, not disclosed.
And next year,
In the morning, you mentioned or not mentioned, all these
page
things
number
irrelevant.
20.
Bail application. Annexure 4, it seems. It is Annexure 4. All citation and everything except that. You know, and, the petitioner has filed the present petition seeking cancellation of the concession of bail granted to the opposite party number 2, while order dated 16/11/2023. The petitioner contended that at the time when the application was moved before the court below, at that point in time, a bail application was pending before this court, which was not disclosed to the court below. By concealing the fact that the bail application is pending before the superior court, the petitioner has persuaded the court below for grant of bail. Notice was issued. I have perused the application moved by the petitioner before the moved by opposite party number 2 before the court below for grant of bail. In the said application, there is no mention regarding the fact that bail application is pending.
Your Lordship, may look at page 27, what the order sheet reads.
1 minute. I am seeking a report from the court below. Which court has granted the bail? Where is the bail order?
Your Lordship, page number 25, Your Lordship.
25. The JMFC Cuttack is directed to furnish a report regarding this aspect by next date appearing. Next date appearing and disclosing as to whether the fact of pendency of the bail application before the High Court was disclosed to the court while passing the order dated
16/11/2020.
Please the matter next week.
Much obliged.
Call for it.
A week after.
Leave this week, next week. Yes.
And that is apparent from the order sheet itself.
Let us see. Let us get a report. The same thing Supreme Court does when High Court passes the order. You know recently what I done.
Much.
Yes. Despite the fact that it is a constitutional court. Yes.
110.
Lord, I have filed the affidavit in persons of your lordship direction. But before I place the affidavit for your lordship.
110, no? Yes, sir.
Can I see, your lordship, can I be allowed to place?
Further.
I've got this instruction as about the non-supply of water, all these things. They are saying it's completely false allegation. They are trying to divert the other
That
way.
we'll see, but what
But
about
their agent is required to be supplied. That is not within our control. Because the agent, they have to pay money and purchase the articles. This year, our officials have said that this we have nothing to say. Only the custom department attends some agent, custom-free products, they will supply inside said city.
See, they are under your custody.
No, they are our custody.
Then it is your responsibility.
But this,
You can't say that
in the
outsource
SIP area, there are two things. One is Coast Guard, another is Port Trust. Third is we are the custody on the law.
Who they are under the custody of your custody.
But we are custodian. Passing on the Port Trust Authority. But Port Trust Authority is
Port Trust Authority also the Union of India only.
But my lord,
Union of India.
Union of India. Ultimately,
Page 75 of the.
Yes.
They are
75.
Yes, 70.
Criminal revision 93.
93.
Season.
Yes. Yes. Where is the valuation report? Have you got it?
But my lord, we can't receive because these officials have filing the affidavit in respect.
Yes, show me. I formulated the proposition. Only you should tell me the valuation report, and he will satisfy me how indemnity bonds have to be. Foreign indemnity bond will be. MK. Yes.
In this affidavit was specifically stated.
Yes.
This way, because this agency, those who have requested to come and valued them, they didn't cooperate and they are not coming. So there is no alternative to whatever document and we have to submit to the court once. A court bill has accepted a value based on the insurance paper. We have to accept this because we don't have other alternative.
Then there is no dispute.
There is no dispute because we are not able to get all these things. The department is failed to do so.
So kind of look at page 75 as I was referring your lordship. Their own document, the seizure memo.
Yes.
On section 42(2) of the NDPS Act, my lord.
Yes.
It said place of seizure is there, date of seizure is there, date of person so and so is there, and reason for seizure on reasons to believe that the seized contraband article suspected to be cocaine seized on the seizure list so and so was concealed in the crane number so and so, the vessel so and seized memo so and so. Kindly look at section 61, my lord. Section 61. Yes.
The reasonable belief that yes.
Section 61 of the NDPS.
61 of the NDPS Act, my lord.
Yes. 61. Yes.
Confiscation of goods. My lord, got that? Section
61.
61. Left side top, I think.
61. Yes. Yes. Yes.
61 says confiscation of goods used for concealing illicit drugs and substances. It says any goods used for concealing any narcotic drug, psychotropic substance, or a controlled substance which is liable to be to confiscation under this act shall also be liable to confiscation. Explanation says in this section, goods doesn't include conveyance as a means of transport. So vessels doesn't come under that. Because they say unreasonable belief.
You are talking about confiscation. It is at the stage of seizure.
Yes.
It's not confiscation. It is only seizure.
Seizure, that's right.
There is a difference between confiscation and seizure.
And seizure, right.
This will apply to the confiscation. But this vessel, the vessel is seized.
But if not liable to be confiscated, you are releasing it on some terms and conditions. Seizure is there. But this is one of part of my submission. This is not liable for confiscation.
Conveyance is not the...
Right. But if your lordship kindly turn to the affidavit I filed for the, since your lordship wanted me to file the affidavit, kindly look at flag B. Flag D.
Page number 9.
The confiscation provision.
63. Then 16.
What he says is 63 will not operate in so far as
60 sub plus
conveyance
3
is
less.
concerned.
60 sub plus 3 less.
There is a bar if something is to be confiscated, then 457 will not lie. He says that this conveyance is out of question of confiscation.
Yes.
So therefore 457 lies. That's their case.
And that has been allowed, Bernard.
Nothing to go here and there.
Question of
So the release is justified. Now come to condition. That's what they say.
Plus, you may come to the for a moment to the section 60 sub plus 3.
60 sub plus
3.
Yeah.
Yes, 60 onwards I am just reading.
Read it.
May I read back? Whenever any offense punishable under this act has been committed, the narcotic drugs, fugitive substances, and control of substance, opium, poppy and coal plants, cannabis materials, and affair to the order such and such, of respect of which or by means of which such offences has been committed shall be liable to be confiscation. Lordship may see prior to this heading of this liability of illicit drugs, substances, plant, articles, and conventions to the confiscation. Very what? Then subclause 2 I am coming. Any narcotic drugs or substances and controlled substances lawfully produced, imported inside the state, exported interstate, imported into India, transported, manufactured, possessed, used, purchased, or
Come to 3.
yes,
Any animal or
any animal or
used in
conventions
carrying
used in
narcotic.
yes, narcotic drugs, amphetamine substance, or controlled substances, or any articles in complication under section 2 shall be liable to be confiscation unless the owner of the animal or the convention proves that it is so used without the knowledge of convention of the owner himself, his agent, if any, and the person in charge or the animal of the conveyance, and that is each of them had taken all responsible precautions against such used.
Yes.
Then Lordship may come to what my learned senior is referring to 61. Confiscation of goods used in
What is your case? Your case is the psychotropic substances. Were concealed in the vessel.
Concealed in the vessel.
Concealed in the vessel, and you had no knowledge. They had no knowledge. When they came to know regarding this, they communicated to you. So it is only the case of concealment. If it's a case of concealment,
right?
then
61 applies.
61 will apply.
This stage we come to a conclusion because on the preliminary, they have intimated, the captain intimate us this the contaminant is there. We have seized the particular
That goes to show that somebody has concealed.
Yes,
They came to know and they intimated you.
Yes.
Sir,
something has been concealed.
The way it was possessed. It is question of possession. Suppose it is not a vehicle, four-wheeler vehicle was possessed. It is a ship, the vessel moved the entire world and different places is come. And this particular article was such a position.
If you could have applied 60 subclause 3,
Yes.
you would have seized. You have not done it.
61.
It is they have given to you.
But here is the case.
Therefore, 61 will apply.
Yes.
No. It is consequential. It is not that. It is because the stage of investigation, we can't come to a conclusion. We can't come to a conclusion that the issue is that they have given. That's why they are exempted from all the issue. No, it is a case. They have informed. That's why from the past date itself, I have confessed. This we can't arrest anybody because the information coming from the captain. But only thing is this: how it is come to that particular.
So therefore, it is 61, sir.
Place, and it was kept in, and we have recovered the same. That was the huge and quantity. It is internal cost will 2,000 crores, and thereafter the investigation is going on, and the conclusion is coming. Any source from which country they have picked up, and what purpose it has been returned. So in this conjecture, what is my humble prayer to my Lord?
Yes.
This my Lord last occasion come to a conclusion.
Yes.
That there is a court is come to a conclusion taking the value. One part is Lordship by confined to value. Another part 100 crores and 10 crores of fund. My submission will be assumption Lordship may see that this court bill has taken rightly. The value is in 115 crores, like whatever things is there. And he is given a an order with his mindset that the 100 crores will be one and 10 crores will be this issue. If they are not agreed to that extent, we are filing another application challenging the court bills order. then it will be create another confused that before the court of law that one way we are coming and filing an application challenging the order of the Honorable Court of the Land Court below. In other way, they are coming in enough application, they are agree to pay the money to the extent that we are not ready and willing to pay the 10 crores or a bond like this such and such. This is the issue now, my lord.
No,
So
they have challenged the condition, you have challenged the release.
Right.
We are challenging both.
You have challenged the release means obviously both.
Both.
But they are not agreed by the fact that the direction was made for the purpose of release. They are only agreed by that 10 crore bank guarantee.
That's why humble prayer for my lord. Last occasion we have prayed the time because we have committed value. Now we are not committing value.
That's
so
right.
Blindly we are accepting their value, what they have insurance value they have given to us.
And your
We are
lordship already
accepting
passed
the
an
same.
order.
But in this respect, what I am saying, my lord, is whatever order has been passed by the court below, that may be accepted order may be passed. Suppose what court below has determined basing on the even though whatever value all these
What you are precisely trying to say is dismiss my petition as well as their petition. That's what you say. That's what you say.
Yes.
You accept the trial court order means you dismiss my revision as well as their revision. That's what you say.
There is no other option with me also.
But I have shown you also the provision with due respect. Sir,
Sir,
he has considered to the effect that the release is all right.
Right.
He is now come to the conditions. Conditions. And in the condition again, he has agreed for one thing that the valuation is correct.
Right.
No problem. Now the question is whether 10 crore bank guarantee.
Bank guarantee, right. That's the only
should be
point.
furnished or not. That the
Right, your
entire
lordship,
thing boils down to that.
the day before the present today, if lordship has already passed an order, lordship, we kindly have a look at that order. Your lordship's order, my lord.
I may commit wrong also.
No, not wrong, my lord. Your lordship observed something. If your lordship kindly see. You.
How much you can pay with the bank guarantee?
Sir, actually, bank guarantee we can't pay because there's impossibility because we don't have anything to pay secure the bank guarantee. Therefore, the bond we wanted the bond made
the biggest
amount will
transporter
be
in the world,
extended.
what submission they have made in that debt? The rupees 10 crore, nothing. As per my knowledge is concerned, what my officers have said, they are agreed to pay. They are agreed to pay. We are ready to pay. Just you get.
What do you say that?
Only what I don't know. How my seniors are saying.
Yes,
This will not dilute the point. In fact, you know, say pass an order. If you say kindly see, the order is there.
Yes.
Therefore, the petitioner agreed with the aforesaid conditions. Second paragraph. Paragraph 3.
Second paragraph.
So the only point for satisfaction is whether it can be enforced or not.
Where are you reading, sir?
Sir, paragraph 7, if you lordship looks at.
Page 3.
Yes. Yes.
I have to satisfy regarding enforcement of the indemnity bond, my lord. Right? That I have shown your lordship last date also. Before that, if you kindly see, I'm sorry, paragraph 4. This is the party learned Deputy Solicitor General India for Customs Department submitted that when the learned court below has passed an order in section 457, no appropriate opportunity was granted to the Customs Department. But in fact, they themselves contested and participated. The Superintendent of Customs objection that is also specifically pressed for grant of time so as to place record the valuation report. Now, sir, there is no valuation report and the report has been accepted. With the affidavit has been placed. In view of the prayer made by the Superintendent of Customs to place on record the valuation of the vessel in the subject, so-and-so has already addressed and so-and-so to private valuer to ascertain the value. Now, that chapter is now over. Your lordship, kindly see, impossibility is a word which I used the last time also. Since we cannot give bank guarantee, it is as good as rejecting my application. Once the release order is there, I wanted if your lordship can enhance the bond amount that also I am agreeable to pay or execute the bond. Bond can be enforced and execution in view of the documents I have filed for your lordship, referring to section 105 of the CRPC.
Show me that.
Yes.
Part. 100?
5. 105 A.
105
A.
The entire chapter of reciprocal arrangements,
Yes.
contracting parties.
Yes, 105.
105 A, kindly see, my lord, capital A.
1 minute, please. 5A. Yes. Yes.
Judgment. My lord, 105 speaks of a reciprocal arrangement regarding process. Am I clear, my lord? 105A says, this chapter 7A, reciprocal arrangements for assistance in certain matters and procedure for attachment and forfeiture of property. Contracting state means any country or place outside India in respect of which arrangements have been made by the central government with the government of the country through treaty or otherwise. Here, the document itself, the document is there on record, my lord.
Yes.
Vietnam is one of the contracting party, my lord.
Vietnam.
Vietnam. My lord, identifying, including establishment of proof that the property
issued for enforcement of this bond in foreign jurisdictions also. And they can also investigate under our CRPC section 166A. So there is no impediment. It is just that it is more of a convenience for them to restrain the vessel here rather than releasing it.
Yes. Yes.
Well, this chapter itself describes forfeiture of the property, enforcement, everything has been mentioned. The CRPC gives a wider range of provision itself.
Yes, Mr. Party.
But kindly look at the affidavit first. One from a humanitarian point of view.
Flag E.
Flag E.
Page 9 is where we are referring, your lordship.
Issue is very small, but
Issue is very small, in fact.
you made so big volume.
Page 9, my lord, kindly have a look at.
9. Yes.
But it is very easy to make imputation and allegations.
Nine.
Very difficult to prove, saying that we are making all false statement. Kindly look at page 9, the last paragraph. Extract condition, mental and physical of crew members. So this is a statement, in fact. Lordship, kindly, this is a statement.
Statement of the master of the vessel.
Statement of the master of the vessels. Begins at page 7, annexure 22. He said, I am the master of the vessel, flying the flag of Panama, the vessel. A copy of my passport and certificate professional committees are here, annex here on that.
Show me where have you informed the custom department that you have discovered this?
That is also there.
Where is that?
Yes,
That was
the extracts are kindly see page 9, my lord. In the morning of 23rd April 2024 at 9:40 a.m., the customs authorities sent the officials onto the vessel to take three crew members. This is only after the order passed by your lordship, my lord, that order. 3 members, AB1 Guy, AB4 Dung, AB5 Tung, out of the vessel to their office. But at 3:20 p.m., LT on the same day, LT means? The officials of the Customs Investigation Agency only brought 2 crew members, AB4 Dung and AB5 Tung, back to the vessel, while AB1 Tai remained in the office of the Customs. Next page, Madam. After AB Tai has been brought back to the vessel, reported to me as below, there is about 6 to 7 people in the interrogation room, while AB1 Tai was answering the investigator normally. There was another investigator grabbed AB Tai here and jerked him back. Then there was also 3 other investigation officer slapped AB1 Tai. After the investigator continued to interrogate. AB1 Tai took him to another closed room. At this room, AB1 Tai was hit hard on the knee by the investigator with a bamboo stick, forced AB Tai to confess. They then forced AB Tai to take off his clothes and crawl through their crotch, and AB Tai did not crawl. Therefore, continued to beat him with bamboo stick, AB Tai's knee and back. Currently, AB Tai's health is severe, detrimental damage. in which he is feeling very sure and uncomfortable throughout his body due to being beaten in various parts of his body.
What is this document? What is this document?
Statement of the master.
Statement of the master, my lord.
From before whom? And how it is relevant to this affidavit? This communication might have
It's all cinema style, everything has been done.
It's okay. It's cinema style. It's, any style. I am not going to say how this document is come to our knowledge. This department must know these things have happened and it was interrogated or this such thing happened. It must be intimated to the higher officials. Those they are all corresponding between us. So it is corresponding between themselves, not to the.
Sir, this has also been informed.
So it was not within these officers are present. I asked him, they don't have a knowledge. They are saying that it is completely false allegations.
But this is an affidavit given by the
master.
Them. You have to
This power of attorney owner file a affidavit before my lord, not by the owner. We want try to get it done. And this authorized agent
why
file
are,
affidavit.
why are you unnecessarily aggravating it?
This we are not aggravating. They are coming a false accusation. They are only to divert of this investigation. Is a international drug trafficking.
I am reserving judgment and pass.
Yes.
If you file anything you want.
Only on one thing, my lord, I am just enlightening.
Small request we have. There are lawyers in Vietnam which are on VC, your lordship. They wanted to make some submissions only if your lordship.
No.
My lord, only one point I am just enlightening. There is 63 subclause 2, lordship. NDPS Act, 16 subclause 2.
Lordship only said rest of the matters, lordship, can it be tomorrow, lordship, some urgent matter. 93 and 94 I'm saying. Tomorrow.
Continue, the list continue.
Item 97 and 91. Can it be taken up any other day except tomorrow?
If anybody wants adjournment, speak to him.
Pardon to make
criminal revision as well as
pardon to make a mention,
Tomorrow
madam.
it will
96 9.
Tomorrow it will remain. If you are not seeking adjournment, it will remain. If you are seeking adjournment, stop.
My lord,
No, no,
106, the private matter of mine. Can it be day after tomorrow? I have some difficulty. Day after tomorrow.
106, 4 दिन पहले. No. Friday will be difficult.
Then Monday, Tuesday, any convenient next week. Next week, any
Eight.
Yes, 8.
Item number 116 adjourn.
Adjourn all the meetings.
Lordship, item number 88, Lordship, extension of time, Lordship.
Tomorrow it will come. But wait.
Lordship.
All the matter tomorrow. All the matter.
And Mr. Padi, if you want to file a written submission, you can very well file.
My lord, yes.
But short written submission because it's so big volume. It is so scary.
If my senior replied, that is, they have some authorized gap. Even though whatever that
only the legal issue which he has.
Yes.
It's between the interplay between 61 and 60.
It can be very clear. Confiscation proceeding concerned is very limited rule to say because
whatever relevant. Yes. If you have any judgment to the court.
Confiscation, it is under the purview, sir.
I may rest of the matter tomorrow.
Thank you.